Mr. Gorbakoff,
Yes, Your Honor.
did I mispronounce your name?
Gorbakoff, Your Honor. You got it right.
Thank you.
Thank you and good morning.
Most of the time I'm wrong.
Well, it's an easy name to pronounce.
There you go. Good to have you with us, sir.
Thank you, Your Honor, and may it please the court. This case involves the core protections of the Fourth Amendment as they apply to the search of a home in which my client, Mr. Suero, rented only one room. Without the warrant in this case, there would have been no evidence to prosecute Mr. Suero for the crimes at issue, let alone to convict him of these crimes. Now, other than the fact that this warrant was supported by a sworn affidavit, some kind of sworn affidavit, every other requirement of the Fourth Amendment.
Well, every affidavit's a sworn affidavit, isn't it?
That's true, Your Honor. Although I think in one of the cases in Williams, I think there was something like a representation from an officer claiming what he found without.
But here there's an affidavit that you're checking.
Here it was sworn, Your Honor, and that is the only thing about this warrant that was legal. Every other aspect of the Fourth Amendment was violated with respect to this warrant. And I just want to briefly hit a few important facts here. The investigation arose here when Mr. Suero's coworker received two threatening emails from a very specific, one specific. And the detective in this case, who both swore and executed the warrant, met with Ms. Olson and found out that the person who had sent these emails was Mr. Suero. He also found out, as it later becomes important, that according to Ms. Olson, she did not believe that Mr. Suero owned a cell phone. Now, Detective Lightly then goes to Mr. Suero's residence and speaks with an individual there by the name of Mr. Benson, who was both Mr. Suero's roommate and Mr. Suero's landlord. And he learned from Mr. Benson only a few facts. Number one, that Mr. Suero rents an upstairs bedroom of this single family home. He rents the upstairs and one upstairs bedroom. Number two, that Mr. Suero in that bedroom has a computer that's connected to the internet. He also learned that Mr. Suero has a ballistic vest and a firearm that he owns. Now, on the basis of those facts, Detective Lightly went and obtained a warrant that allowed him to obtain not only computers, any computers in the home, not only firearms, any firearms in the home, but also a slew of digital and electronic devices, including storage, hard drives, thumb drives, PDAs, and just every conceivable electronic digital media type of computer type device, including any cell phones in the house. He did not include in his warrant affidavit the fact that not only was there no evidence that Mr. Suero didn't own a cell phone, but the fact that the evidence he had actually showed that Mr. Suero very likely did not own a cell phone. There was nothing in this affidavit to suggest.
About everybody owns a cell phone anymore, don't they?
I'm sorry, Your Honor?
About everybody has a cell phone anymore.
That's generally true.
That's generally true.
At least at the time of Griffith, it was about 90% of people who own a cell phone. But the court in that case said just because it's common to own an item is not sufficient to go ahead and get a warrant with no evidence, especially for something as sensitive as a cell phone. Now, the problem in this case is that it's far worse than Griffith because—
Why does the sensitivity matter? I mean, you know, we have this line of cases from the Supreme Court that talks about the ubiquitous role that cell phones play. And as Judge King indicates, I mean, most people have a cell phone. They're not all smartphones. Some folks have flip phones and the like, but most people, and it may be true that your client was the extraordinary exception, although it at least might have been thought that. But why does the sensitive nature matter? If the reasonable assumption is that almost everybody has a cell phone, and so searching for it because it can send emails and other things seems like a perfectly reasonable thing to do. Why does the sensitivity of it make any difference? You seem to want to focus on that. I'm curious why that matters.
I don't think it's a major focus because you still have to have some evidence that somebody owns an item. You can't just receive evidence that they don't own an item and then ignore that, not tell the magistrate judge and go ahead and search for the item. But setting that aside.
But you didn't ask for a Frank's hearing, right? You didn't, this wasn't a Frank's question, right? You didn't say that the district court or the magistrate was misled, right?
Well,
and you agree that we can make reasonable assumptions about what people do. If 95% of people own a cell phone, it's not unreasonable to believe there's probable cause, right? Not certainty, but probable cause to believe that he owns one.
Well, Judge Richardson, a couple things. So number one, in Griffith, which I understand is not binding on this court, but in Griffith, the DC circuit said that just because it's common, virtually everybody owns a cell phone, that in itself is not enough to assume that this specific person owns a cell phone. In fact, according
we also know that this person is using electronic communications, right? So we know he's not a troll under a bridge, right? You know, sort of a Luddite who doesn't want to use technology, right? So I mean, it seems like to me here, like we've got more than probable cause to believe that he was using electronic devices, and given the prevalence of them, that he would be using a cell phone. Probable cause, not certainty, just probable cause.
I think this case is very unique in that regard, Your Honor, because again, we cannot overlook the fact that the detective in this case, the only information he had was that Mr. Suero did not own a cell phone.
Well, that I don't believe he owns a cell phone, right? Mr. Benson says, I don't believe he owned a cell phone.
It was Miss Olson, right? But the fact is that the detective then took no further steps to then ask, for example, Mr. Benson, well, I hear he doesn't own a cell phone. Is this accurate? A police officer can't just receive information that somebody does not own something, likely doesn't own something, ignore that, not include it in the affidavit, and then go ahead and use his own judgment to say, I feel like my investigation, you know, I don't like the results of what it says. I'm going to go ahead and ask for a cell phone.
Hey, Mr. Gorfkopf, though, I think your time is moving pretty quickly here. We need to hear from you on why the good faith exception under Leon doesn't apply in this case.
Yes, Your Honor.
Because I haven't heard anything to suggest that the officer recklessly disregarded the truth, that the magistrate wholly abandoned his judicial role, or that the warrant was so facially deficient that the executing officer could not reasonably presume that it was valid. So what do we have in this case, based on the record, that would fit you within one of those Leon exceptions?
Yes, Your Honor. There are multiple grounds for that. And I'll start by just noting that the Leon exception is the reasonable officer, objectively reasonable, well-trained officer. That's the standard under the Supreme Court. And so we begin with the fact, and going back to Judge Richardson's question, that a reasonably well-trained officer cannot ignore or omit information from his warrant that suggests the defendant doesn't own the item that he wants to seek. He has to do something more.
Right, but the Leon language in our cases that have applied Leon suggests that some intentionality is required. There has to be some evidence that the officer willfully did something or recklessly disregarded something. What was recklessly disregarded in this case?
Well, I think the facts easily show recklessness, Your Honor, because he went out, he specifically asked somebody, does he own a cell phone? They said, I don't believe he does own a cell phone. Took no further steps to find out whether he owns a cell phone. Then in his affidavit, omitted the fact that he had information that Mr. Suero likely does not own a cell phone, and then went ahead and proceeded not only to seize Mr. Suero's cell phone, but to get authorization to seize any conceivable cell phone in the house, regardless of whom it belonged to. If that is not recklessness and that is not objectively unreasonable, Your Honor, I don't know what is. But moving on, a reasonable officer cannot seek a warrant that is much broader in scope than the probable cause he has. Officer Lightly knew that Mr. Suero occupied only one room of this residence. He had no information, and certainly nothing he put in the warrant, that would suggest he could search the entire residence, that Mr. Suero kept his items throughout the house. He had no information like that.
But he had no information the other way, right? So he rented an upstairs bedroom, but was there information that he had no access to the remainder of the house?
There was no such information, Your Honor, but the relevant question.
I mean, typically, I'm not a big boarder, right? But seems sort of the natural inclination is that if you rent a bedroom in a house, that you continue to have access to the kitchen and the den and the, the remainder of the house. Maybe there are places where you do not, right? But you generally have access to something beyond the bedroom. In fact, you got to walk through other places to get there.
That would be a fair assumption, Your Honor, if Detective Lightly, if it was something that in fact he had and he put into the affidavit, but also the fact that other people.
But we say like you don't have to put common sense like beliefs and understandings in, right? You don't have to say, you don't have to like dot every I and cross every T in an affidavit, right? Like he doesn't need to say in order to get to his bedroom, he has to walk through the den. Like that's just sort of an understood part of what we're doing, no?
Right.
But he has to legally get access with the approval of the magistrate, correct?
That's correct.
And he did, because he got a warrant from the state court magistrate, right?
Right. Well, the question is if the warrant is valid, and here
I understand.
we submit that it's
And you want to suppress it.
grossly overbroad. Yes.
And they went to trial on child pornography charges
Yes, Your Honor.
in federal court and got convicted. And you don't raise any legal issues about the trial or that portion of the record, right?
Solely the sentencing, Your Honor. But
Sentencing, right? But as to the trial, you don't make any complaints of error.
No, we would, other than that, we wouldn't have had a trial if this.
Yeah, but if you can knock out this evidence, there wouldn't be anything to try you.
That's right, Your Honor. And going back.
But you do say that the sentencing was a little bit out of whack.
Yes, the district court did.
That's what we got here. I mean, I'm trying to move along here to get you to focus. And the government maybe we're going to hear from here in a minute. They may be ready to acknowledge some problem with the sentencing for you.
They may, although I doubt it. But the chief problem with the sentencing, Your Honor. Would you like to hear about our issue with the sentencing, Your Honor?
No, I'm just. It's up to you. Whatever you want to do.
Thank you, Your Honor. I would just briefly. I do think that the suppression issue is so central to the case that I did want to continue to
Well,
finish.
you knock the whole thing out with us if you could get us to agree with you on suppression. Yeah.
Yes, Your Honor. That's exactly right, and that's why I think good faith is an important question. And to go back to Judge Richardson's point, I think in Maryland versus Garrison, the Supreme Court said that if officers knew that multiple individuals occupied the floor of a building that they were going to search, that warrant would not have been valid for them to search the entire apartment. The only reason it was valid was because they did not know that there were two people that lived up there.
Can I ask you about a Supreme Court case called Ross? And then Ross stands for this proposition. And if I can go over just a minute, it stands for this proposition that you can only look in locations where the nature of the object might be found, right? And so if you're looking for, a 6 foot tall sculpture, like you can't look in a bedside drawer, right? And so this is the idea that the nature of the object determines the places that you can look. And the warrant and affidavit here, directs to look for instrumentalities and evidence of threats, these particular threats from your client. And so why wouldn't we understand that the warrant, like in Ross, is properly limited to locations where evidence related to that might be found? And so if an officer, for example, went into Mr. Benson's bedroom, it'd be like looking in the bedside drawer for a statue, right? That it's not reasonable for an officer to believe that he's going to find evidence of your client's threats in the bedroom of somebody else any more than it might be reasonable for him to look perhaps in the freezer for such evidence.
Yes, Your Honor. If I may, I'm over time, but
I think
as long as you get questions, you go ahead and answer them.
thank you, Your Honor. I appreciate that.
You go right ahead.
I think the answer, Your Honor, is in attachment C, which is the list that controls. First of all, there is no such narrowing that it's associated with the crimes. The only two.
All right, but assume for a minute, just to help me
Yes.
focus my question, assume, I think paragraph 3 of the affidavit does that. And so just assume that I think it is so limited.
Okay, then we move to the next point, which is what is this, what the Supreme Court has said that the particularity requirement is geared towards the executing officers, the officers who are executing the search. Now, that doesn't matter in this case that it was Detective Lightly. That doesn't magically save the warrant because we still have to look at the four corners of the warrant and the affidavit. And what the Supreme Court has said is that if the particularity of the warrant is such that an officer executing it, looking at the warrant, goes in the house, I mean, a cell phone could be in anybody's bedroom.
Right, but you understand my concern is the warrant that's looking for the 6 foot tall statute doesn't have to specify that the bedroom drawer is excluded because an officer looking at the face of the warrant says, statute not in bedroom drawer, right? And similarly, reading this affidavit, you understand who the person is that's making the threats. You understand there's another person there named Mr. Benson who's not making threats, who's cooperating. And so a reasonable officer walking in says, that's Mr. Benson's bedroom. It is not likely that I'm going to find the statue in that bedroom drawer.
The problem, Your Honor, is that there's nothing in the affidavit or in the warrant that says which bedroom is Mr. Benson's, which bedroom is Mr. Suero's, or which bedrooms are the four other roommates who live there. There's nothing in the warrant that would allow an officer executing this warrant to say it's the upstairs bedroom on the right.
And so absent, your view is absent law enforcement's ability to have like the floor plan of the house, they can't search it at all.
My view, Your Honor, is that is exactly in line with Groh, which is that if an executing officer looking at this warrant had no idea where to look in the house, then that's an overbroad warrant.
Thank you, Judge.
Thank you, Your Honor.
Thank you. You have some rebuttal time. Mr. Cook, you out there?
Yes, Your Honor.
Good.
Thank you. May it please the court. I'll start with the Fourth Amendment issue. The defendant's principal argument, as I understand it here today, is that the warrant is invalid and lacked probable cause or lacked particularity because of the inclusion of a ability to seize a cell phone. What the officers knew in this case was that the defendant had sent threats via email, and it is perfectly reasonable for a warrant to request and a magistrate judge to approve a search for a cell phone that could be the source of where a defendant sent email, because it's common knowledge that you can send email using a phone. As it happens, none of the evidence in this case comes from a cell phone. It comes from the devices that the police seized in the execution of the warrant. So I think that the cell phone issue is rather attenuated as a basis for suppression. It's not been the focus, I think, of the briefing on appeal.
Mr. Cook?
Yes.
If the officer here executing the search warrant, was he limited to looking for items believed to be evidence and instrumentalities of threats?
Yes, I mean the warrant has to be read through a combination of aspects of the warrant. The first would be that the warrant identifies the particular crime that they are investigating, and the crime that they are investigating is death threats, and that's in paragraph 1, and it gives you the code section. And as this court said in Cobb and in a bunch of cases, that the identifying the crime that you are investigating helps address the particularity requirements. So that's number one. Number two is that the place to be searched is described as the residence of Mr. Christopher Suero, and that, I suppose, could be viewed as ambiguous and as encompassing the residence of anyone in that building. But I think the fair reading of it is that it's referring to the defendant's residence. That's what it says. And really the overbreadth analysis here is not about excising words. It's taking a phrase and saying this is susceptible to two readings. One is that you can search the defendant's residence, and the other is that anyone who lives in that building. And I think that it is a reasonable application of the overbreadth doctrine to say, well, we're going to construe this to mean the defendant's residence. And that would encompass places common areas that he has access to, as well as his bedroom. I don't think that the police have to be limited in that respect. But we're talking about warrants that the case law has said are drafted in haste by people that are not lawyers. And I think it's reasonable to construe the phrase here, the defendant's residence, as encompassing the places where he has access to and could have the evidence. And then the third thing is the warrant refers to the various places where evidence of this email death threat might be found. And it identifies, of course, the defendant as the person that is suspected of sending the death threats. And so naturally, a search would be of electronic devices the defendant could have been using. And so I think that adequately constrains the scope of the search. And
so, Mr. Cook, do you agree? I mean, if they had gone and searched Mr. Benson's bedroom, which I have no reason to think they did, but had they done that, would that have exceeded the authorization of the warrant?
I think it would have. And the detective testified, and this is Joint Appendix page 209, that he did not search other bedrooms. But I do think that it would have been. Now, this would be a question about the reasonableness and the execution of the warrant. And if the officers had reason to think that a particular room included was one the defendant had access to, I don't think that would be unreasonable. But if the evidence before them was this is a room that belongs to somebody else, the defendant doesn't have access, then I think that would exceed the scope of the warrant read as a whole about where they could search.
Would this fellow complain about it, or would it have to be the other resident complaining about it?
Well, I mean, I don't think the defendant would have standing to complain about a search.
What I'm getting at, he wouldn't. Yeah. It wouldn't be his. It wouldn't be his issue to raise.
Right. That's right. I agree with that. He would not have standing to complain about a search of Mr. Benson's bedroom, but that didn't happen factually, and I don't think the warrant fairly read would have authorized a search of a bedroom known to be Benson's and not the defendant's.
I don't want to get you sidetracked, but I'm interested in your views, particularly in light of your recent letter with respect to the sentencing issues. Unless you have more on the Fourth Amendment issue.
No, I'm happy to turn to the supervised release condition. And Your Honor has suggested, or the panel suggested, that the government might be willing to give some ground on the conditions of supervised release, and I'd like to elaborate on that. As I indicated in the letter, really the point on which we're willing to give a bit of ground would be solely the condition that addresses the defendant's, this is condition 6, the defendant shall not engage in employment or volunteer services that allow him access to a computer. I think when you read that condition with the other conditions in this case, I don't think that the district judge's intent with that condition was to say, you're working in a manufacturing facility and there are robotic devices that use computers, you can't work there. That would be, I think, in no one's interest. We don't have an interest. No one has an interest in having the defendant be unemployable. And I don't think that's what the district judge set out to do. So I think it would be okay to have the district judge clarify that condition. I don't think a total resentencing is necessary. I don't think this is a device to revisit the total sentence in this case, but in much the same way that the gaming console restriction was narrowed to communications essentially to reach children, use the console to communicate with children or access websites and download information. The point should be that the work computers shouldn't be a way to evade the internet monitoring that the defendant doesn't even challenge. I mean, the defendant doesn't challenge condition 11 that requires computer monitoring programs of his computers. I would think that most employers are not going to be happy with the probation office having monitoring programs on their computers. So if you're talking about a workplace environment where, in order to ensure that the defendant isn't getting on the dark web on the workplace computers, you need to have computer monitoring devices, then I think that would be a reasonable restriction to say the defendant can't have access to that kind of computer.
Now, Mr. Cook, with regard to the adult pornography condition of supervised release, do you have a problem with that restriction in light of our recent decision in ARS, our March 8th, 2022 decision, where the court upheld the restriction based on evidence in the record that the defendant had an addiction to pornography, and that this created a serious problem that while a general ban on adult pornography might have not been appropriate, in that case, the evidence indicated that it was appropriate. Do we have any of that kind of evidence in this case regarding an addiction by Mr. Suero to adult pornography that would bring him within the language of ARS?
Right. So I would address that in two parts. Part one is the district court's explanation, and part two would be whether the evidence would support such a restriction. And let me start with just does the evidence support the restriction? And this is a somewhat unusual case. And what makes this unusual with regard to this pornography restriction would be that the defendant started off, and this is in his sentencing position, Joint Appendix 1206, and at the sentencing hearing, Joint Appendix page 1519, where he affirmatively was asking for inpatient mental health treatment and sex offender treatment. So that starts you off in a fairly different scenario. And the reason why the defendant was doing that is that he was seeking to make use of and succeeded in saying, look, the defendant has some serious mental health problems. You should give him a lighter sentence, and that you should supervise him on supervised release as a substitute for incarceration. And the district judge said during the sentencing hearing, and again, this is page 1519 of the Joint Appendix, he said, Mr. Suero has had 28 years of opportunities to one time show that he's willing to help himself, and he has just frankly failed to do it at every single turn. Every doctor that we've read these reports about have said the same thing, that he's got to be willing to help himself, and he's just unwilling to do that. And defense counsel responded, yes, but what's different here is that you can have the coercive power of the conditions of supervised release. Okay, so that's the first step. The next step is we have this defendant's got a huge collection of child porn.
Right. But what does Mr. Cook, if you'd focus, please, on what this has to do with adult pornography? It seems to me that you want us to just jump over, because he's got a problem with child pornography, to say that all access to adult pornography is likewise appropriate to be limited, and don't we have a problem with that?
I don't think
evidence so. that he has an addiction of some sort.
I don't think so. When you're talking about a defendant who is saying, I need sex offender treatment, I don't think that it's an abuse of discretion or here under plain error for a court to say that's going to encompass both adult and child pornography for a defendant who is known to be really unwilling to comply with any kind of limitations. I mean, this is a defendant who plainly has a problem with self-regulation. I mean, the death threats alone show you that, regardless of
was there any evidence in this case that he had accessed adult pornography?
I mean, there was access to the dark web.
But was there evidence that he was frequently using adult pornography in conjunction with child pornography to suggest that in his mind that he was conflating the two? Is there anything in this record?
Candidly, I could not tell you whether in the evidence in this case there was adult pornography or not.
Okay.
But I think that where you have again a defendant saying, "I need sex offender treatment," and a judge says that's going to encompass limiting your access to pornography generally, and more specifically child pornography. That's a reasonable inference. Put
Okay,
differently,
could you move on to video games then? That seems awfully broad to me. And you know, I understand the good intentions of the court. It's just when they bump up against First Amendment considerations about the right to access and you know, to read these materials. Um, so why is the video game condition of special release not overly broad?
it's not for a couple of reasons. One is the defendant has the ability, if he wants to play video games, because the computer monitoring restriction in condition 11 allows him to have computers that just have to be monitored. And the gaming console restriction isn't a restriction on all gaming consoles. It is a restriction on one that, quote, enables him to contact and or share data with other individuals. And so
So he can't play games with other people? Is that what you're saying?
exactly. And the point for that is because such a console wouldn't have the computer monitoring that's set forth in condition 11, but would enable a defendant to reach out to other children and communicate with them, or just generally access the internet and download child porn that way
Okay,
undetected.
but the district court's condition isn't limited to playing games with children, is it? It's also adults.
It's
He's not,
other individuals, but that's because that's a mechanism to be able to, again, evade the computer monitoring in condition 11. I mean, I think that if you have a gaming console that is capable of having computer monitoring software on it, you could say that that just fits within condition 11, which allows them to have computers. I mean, I don't think there's anything special about the fact that a particular device is aimed at gaming. It's really the monitoring. So reading together condition 11, which is, yes, you can have computers. We're not banning you from having personal computers that would even have access to the internet. It's just that there has to be computer monitoring that ensures that you, a defendant who's been willing to use the dark web, which is exceedingly difficult to monitor, can't have devices that are bereft of a monitoring device. And so I think read together, those are perfectly reasonable limitations. And particularly in the context, again, this is plain error. The defendant did not object to these in any respect. And so he would have to show, he's pointed to a passage in this court's opinion in Ellis that is not deciding this question and did not, was concerned with a dramatically broader restriction on any kind of computer games, which is not what we have here at all.
Can you tell me a little bit, Mr. Cook, just so that I understand conceptually, and I know we've done it a couple of times, but I'm just looking for some advice for you. In cases where, hypothetically, let's assume that one or more of these supervised condition release conditions either needed clarifying or needed to be removed, how can we do that? Do we have to send the entire sentencing back as a package? Or can we just send it back for the limited remand to address, let's say, condition 6 and condition, the adult pornography condition, for example? Can we limit the remand in that way on a sentencing? Is that an appropriate thing for us to do?
I think you can. I guess the first thing I should say, I don't believe this court's precedent is highly developed on that. Other circuits have probably done more in the way of limited remands. Generally, this court is ordering a de novo resentencing, where you're looking at a case in a sentencing package type, framework, it would make sense to have the whole sentence sent back. And in this case, I think that if what was imperiled was a condition that was really central to what the balance struck by the district judge, like let's suppose, no computer monitoring is permitted. He just has to have wide open access and no, sex offender treatment. Then the district judge might want to revisit the length of the sentence, frankly, if supervised release was going to be that toothless. What we're talking about here, I think, reasonably, and perhaps I'm misconstruing the district court's intent, but I just don't see, for example, the condition on the work access to a computer.
So I understand that framework. When you say our case law is not very developed here, help me understand. You know this case law as well as anybody. Have we required a full remand, or have we just not addressed this issue? I understand the sort of playoff, and it seems like in a number of cases we have sent it back for a full package remand. But I guess I'm trying to figure out what does that playing field look like today in the Fourth Circuit, understanding that other circuits have been a little more nuanced about it.
Right. Well, and I wouldn't say that this court has been unnuanced. I just think it hasn't spoken to it a whole lot. The court can certainly let me know I'm wrong about this, but I understood the ARCA remand not necessarily to require a full de novo resentencing, but just a clarification of the conditions there. More than a ministerial correction of a judgment, but not a need to revisit everything that had already been done. And I guess it's of a piece with the scope of the mandate. In sentencing, you can send a sentence back for resentencing where you say everything start from scratch. And in other cases, it could be just revisit this guideline and then apply the 3553A factors. And that just depends on how the court chooses to write its instructions for the remand.
It'd be reserved to our discretion, would it not? It'd just be up to the panel in the case.
Exactly. And I think that discretion would be informed by a judgment about the centrality of the condition to the judge's overall sentencing determination. And if you're talking about something that appears to be relatively peripheral to the overall sentencing determination on a condition of supervised release, it would be totally appropriate to send it back for clarification of that one condition without a need to revisit everything. And essentially what would be going on here is a combination of a fairness determination along with a judicial economy type determination, that if in the panel's view, the problem is really a very narrow one in the sentencing that does not disturb the global assessment of the sentence, the district judge doesn't need to replow all the ground of a de novo resentencing. It's just not needed. And is not, the error doesn't reach that. It doesn't require revisiting all those issues. But if in the panel's judgment, no, actually, this really could be relatively central to the, overall sentencing determination, just start over and do it again. And that's just up to the court.
Thank you very much, Mr. Cook.
Thank you.
Appreciate it. Mr. Gorikoff, you've got some time reserved.
Yes, Your Honor.
Do you mind starting with what we just finished with? Whether you, understanding we probably have discretion to do it one way or the other, whether you think there's a reason why, if hypothetically we agreed with you, but only with respect to several of the supervised release conditions, whether that would require a full resentencing, which might result in a higher sentence or a lower sentence for your client, or whether we should limit it to the particular issues that we find?
My position would be, Your Honor, that the sentencing package as a whole matters. So if the judge is going to be tinkering with one aspect, he should have the discretion to adjust other aspects of it.
Understanding that if you're lightening the burden on the supervised release condition, the only sort of like likely outcome there would be a longer sentence because of the inability to control.
I'll confess, Your Honor, that since it's a de novo resentencing, I would try to do a better job of trying to show this district court that my client, a mentally ill man who's got non-contact offenses, solely child pornography offenses, got sentenced to 3 or 4 times more than the average offender who does the same thing, and more than sometimes violent, sometimes non-violent, hands-on contact sexual offenders. I would like an opportunity to make that case de novo, Your Honor. So I'll be honest about my motive.
No, I appreciate your honesty.
Your Honor, going back to some things that Mr. Cook said here. Number one, he said that no cell phone was seized. I just want to point out that that fact has absolutely no bearing and no relevance under the relevant analysis. No, none at all. The analysis is the facial validity of the warrant. Secondly, he stated that the cell phone was the focus of our appeal, and I would respectfully say, while it's a very egregious issue, it's not by far the only issue. There's as I mentioned, Your Honors, there's a slew of items here that were seized in this case, and overbreadth by also is not the only issue, because there's also a violation of the requirement that there must be a nexus shown, at least by some showing. Conclusory statements aren't enough. Here, there were no statements at all as to how Mr. Suero's offenses relate to the slew of things here on this attachment C, other than computers and arguably a firearm and a vest. We'll concede those for the purposes of this argument, but there was no nexus, nothing, not even an attempt to show how there was a basis to seize all of these other things on this list. And finally, there was no attempt to show that these items would be found at the residence, because again, there was no evidence that they existed at all. These are 3 separate independent requirements. So even if we set aside overbreadth, the nexus to the offense is not a formality. It's in the Fourth Amendment. It's the Supreme Court has said it again and again and again. The fact that there has to be a showing of probable cause that these items will be found in the residence has to be shown. Cell phone being the most egregious example, but there's, again, not even a conclusory statement. Mr. Cook mentioned that there are 2 readings of the 2 possible readings of the affidavit and the warrant in this case, and that is the very problem with it. That is exactly the problem with it, because under Supreme Court law, anything that when this kind of warrant leaves something to the discretion of the officer, especially something as vital as how to read the warrant itself, it cannot be valid. That goes against the very purpose of the Fourth Amendment, which is to limit the discretion of the officer in interpreting the warrant. And the fact that this affidavit identified a crime and a person that was being looked at is not sufficient, because in Maryland versus Garrison, it identified the target of the search, McWebb. It identified his crime, marijuana. Yet the Supreme Court still said that if the officers knew multiple people occupied the 3rd floor, the search warrant wouldn't have been valid. The search warrant would have been overbroad. And that is exactly the knowledge that Detective Lightly had in this case. The Fourth Amendment requires that the places to be searched be specified with particularity. If you only have information that someone occupies a room, specifying an entire house without limitation is just flatly contradictory to the text of the Fourth Amendment. And again, here, there was nothing to identify the room, nothing to give officers guidance as to where to go and what to do. And the fact that they decided to rely on Mr. Benson to take them upstairs and show them where the room was is exactly the kind of discretion that's prohibited by the Fourth Amendment. That was a discretionary decision made by the officer as to how he was going to conduct the search. Finally, there was an issue about standing. And I think the law is fairly clear that as to, if these individuals had their room searched, they might have had a 1983 claim, no doubt about that. Mr. Suero wouldn't have had a 1983 claim on their behalf. But the question here is, does Mr. Suero have standing because it exceeds his room? And certainly he does, because again, the question comes down to the facial validity of the warrant. Going back to the issue of good faith, I just wanted to point out that, yes, Judge Richardson asked me, did we raise a Franks issue? And the question and the honest answer to that is no, we never used the word Franks in relation to this fact that Detective Lightly omitted a critical fact that had the magistrate known, there would have been no probable cause. So we never used the word Franks, but we repeatedly.
And the fact that you're talking about is that the woman being threatened said that she didn't believe
Right.
that he had a cell phone.
Right. The coworker that saw him daily and based on her daily interactions with Mr. Suero, told Detective Lightly point blank, I have no information that he actually has a cell phone. And the ubiquity of the cell phones again becomes relevant here because as we know, people are walking around with their face stuck in the cell phone all the time. So the fact that this coworker of Mr. Suero, who interacted with him on a daily basis, actually told Detective Lightly, no, you know what? I really don't think he does have a cell phone. That's a biggie. That's a big point that for Detective Lightly then not to mention that to the magistrate, it doesn't just flunk Franks, it just flunks that a reasonable officer should have known that there's no probable cause for the seizure of the phone that he sought to seize. So independent of the fact that it was a reckless misstatement or a reckless omission, under the other branch of good faith, Leon good faith, just a reasonable officer should not omit information so vital from a warrant. Thank you, Your Honors.
Thank you, Mr. Gorokoff, and I particularly want to thank you for handling this appeal. You're court appointed, to understand, and we appreciate the work you do and your contemporaries that handle these cases, and we really do appreciate it. We couldn't do our work without yours. With that, we'll take this case under advisement, and Madam Clerk will reorganize the council tables and go to the next case. Yes, and representing the city of Durham, Mr. Church.
Yes, Your Honor.
Good to have you with us, sir.
Thank you, Your Honor. May it please the court. This case arises out of a collision between a train and a vehicle that plaintiffs allege was caused by an overlength crossing gate. And here the plaintiffs sue the city of Durham with respect to that crossing gate. The district court erroneously held that the city's general duty to maintain streets and sidewalks applied in this case to the allegedly defective railroad crossing gate and pierced the city's governmental immunity. That decision is wrong for at least two reasons. First, the crossing gate is a traffic control device, and cities are entitled to governmental immunity for the installation operation, and maintenance of traffic control devices. Second, a railroad crossing gate is not a public street, sidewalk, bridge, or alley, and its maintenance is governed by separate statutes that the district court failed to apply here. Because the district court erroneously failed to apply the correct law, we ask this court to reverse the district court's grant of summary judgment.
I'm sorry, can I make sure I just understand? I want to understand the two framework. Your second point is that where the long gate, what I'll call the long gate, just so that I understand, that it didn't go over a street?
No, Your Honor. Well,
Because you said it's not a public street. I mean, when I look at the diagrams and pictures, it looks like a street.
so
Well, and the plaintiff was certainly on a public street when he was hit by the train.
And so I can answer both of those questions, I think, together. The distinction here is not whether a railroad crossing is or is not a public street. I think that question doesn't need to be resolved in this case. The issue here is that a crossing gate is in itself regulated by a separate statute than the public streets and sidewalk statute. And so when we look to see what a city's obligation is with respect to a railroad crossing gate, we need to look to the specific statutes that regulate railroad crossing gates and not the general statute.
So I understand, but I think we do have to resolve the question because you said it's not a public street. And so I just want to make sure I understand the arm that comes down that's allegedly too long. I'm going to not use allegedly, but just given where we are, like the ground that's underneath that gate is a street, right? I mean, I don't understand how, I understand you might want to talk about the railroad itself is not, but like the ground underneath the bar, I think we've got to, if we don't agree that's a street, then we've just got a fundamental disagreement about like the facts.
So for purposes of this argument, we can assume that's a street. I don't.
Well, you should know
is a
if you
street.
represent the city,
How-
you
how
should
can it
know
not
if
be a
it's a street or not.
Yes, yes, and I think that there is a question, I think an open question on the record, admittedly, as to the physical ownership of the space. You know, did the railroad own the tracks?
Well, it's a street,
But
but it may be a question of who owns the right of way or something.
That's
But
correct.
the city of Durham uses it as a public street.
That's correct. That's correct.
And there was a railroad traffic bar that came down and they claimed the bar was too long. And they ended up causing the train to run over the pickup truck and injure people.
That's correct. And so the question here is not what is the city's general duty to remove
And you claim
obstruction?
immunity, sovereign immunity. And you want out of the case, the city's not liable because it has immunity.
That's correct, Judge
From
King.
with respect to that, whether that traffic bar or whatever it is safe.
That's correct. And the question here is not what the
And Judge
city,
Eagles threw you out, said that part out, said she was not going to give you the immunity.
that's correct. And the
You're
question,
here on an interlocutory appeal.
that's correct, Your Honor. The question here is not the city's general duty to maintain a railroad crossing free of any random obstruction. So we're not talking about, for example, a boulder that was dropped in the intersection. What is the city's duty to remove the boulder? We're talking about what is the city's duty to remove crossing gate? And the crossing gate here is
No,
specifically.
it isn't the duty to keep the streets safe for public passage. And it seems to me that at least my perspective, and perhaps you could address this, is that in order to prevail in this appeal, you're going to have to convince us that these statutes can't be read harmoniously. And I don't see why they can't. The city can certainly elect to do certain things, contact the railroad, but that doesn't remove the city's duty to keep the public streets safe. And to me, the key is to this case is how you characterize the duty. And it seems to me that you're talking about the duty to alter the gate when the duty that's alleged in this case in the negligent act was in not keeping the streets safe for passage. And I think that opposing counsel makes that point in its brief. by saying we're not trying to keep trying to say that the city had a duty to cut the gate down to size. What we're saying is the city had a duty to, if it wasn't going to do anything with the crossing gate, it had a duty to divert traffic. The duty is the street, and the city's duty under 296 of the statute of the state code to keep the street safe. And so why can't these statutes be read harmoniously? I don't think you've answered that in your brief.
The duty depends to some extent on the nature of the obstruction. And when the nature of the putative obstruction is a traffic control device, the city is immune from any supposed liability with respect to the.
But what she's asking is why do you read 296 to include this parenthetical at the end, right? That is, except when it's a crossing gate.
Because
it just says obstruction, right? Keep the street safe, remove obstructions.
And the North Carolina courts, going back to Cooper, have defined obstruction broadly to.
This is a state law issue, right?
Yes, Your Honor.
The state law issue, you want us to decide this state law issue. Why don't you go to why don't you stay in the state court and let them resolve it?
Well, Your Honor, this to answer, I'll try to answer both questions. This case was removed to federal court because there was a federal instrumentality involved in its state.
It's no longer in it.
That's correct. The court could have dismissed it, but it exercised supplemental jurisdiction.
And we can't certify this to the Supreme Court of North Carolina. They don't have a provision that lets us do it.
That's correct. So
we ought not to be even deciding state law.
We need to follow state law.
We got enough federal issues we have a hard time figuring out.
And we can follow state law. And Judge Richardson, to answer your question, with respect to state law in Cooper has defined obstruction broadly to can be anything that makes passage less convenient or secure. And that would include the defective operation of a traffic control device. But the North Carolina courts have uniformly said that when a traffic control device is defective in any respect, the municipality is entitled to immunity.
The difference in those is that those cases, they were not an obstruction. You had an inoperable traffic control signal. The other case, you had a stop sign that had fallen by away from the road. There wasn't an obstruction to the public street in either of those cases. And you have an obstruction to the public street. In this case, by your own admission, it's a public street.
Actually, the immunity for installation, operation, and maintenance of traffic control devices stretches all the way back to the Hodges cases versus City of Charlotte in 1939. And in that case, the immunity was accorded when a truck was in a traffic collision on its way to repair traffic lights. And the court said, this is a governmental function. Replacing traffic lights is a governmental function. And what happened in that
right,
case,
but they weren't. The court wasn't. Was it? Correct me if I'm wrong. It wasn't addressing the obstruction language of Section 296.
It wasn't in play there, but it shows the breadth of immunity.
Right, but Cooper acknowledged that. I mean, Cooper said that an obstruction can be anything, including vegetation, which renders the public passageway less convenient or safe for use. And this certainly, the long crossing gate certainly made it unsafe for use. So how do you get beyond that definition of Cooper?
And then when you look at the court's decision in Sisk, in which the plaintiffs in that case alleged that the city had failed to control traffic, and the court said, notwithstanding what Cooper says about what an obstruction can be, we don't read Cooper to say that an obstruction is anything that makes it less convenient or safe.
Right, because a traffic control device isn't an obstruction, and state law kicks in to say that if a traffic control device is inoperable, certain other rules of the road apply, namely the driver on the right or different rules. So that's not an obstruction, as we have here, which is an obstruction. So you've got to explain how you get beyond that Cooper definition, I think.
The difficulty here is, crossing gate is designed to be an obstruction. It is designed to come down and obstruct traffic. So the difficulty here is if we say, okay, well, a railroad crossing gate, when it's defective and it obstructs traffic incorrectly, then the city's liable.
Right, but the statute says unnecessary obstruction. Okay, so having the crossing gate extend into the opposing lane of traffic is not necessary to control the traffic on the road.
Well, in that sense, the district court erred in resolving that matter as a matter of law for the plaintiffs in any event. There was at least evidence in the record that.
Yeah, but you didn't appeal that. So can you talk to me for a minute about, assume you lose on everything you've said so far? You seem to make a separate argument about Wilkerson, right? Under Wilkerson, which says if it's an obstruction and you have a duty to clear it, you don't have a duty if you lack control over the item, right? So if it's vegetation growing on the railroad's property, you lack control over that vegetation, and by control, direct control. And so even if you would have had a obligation, you don't because you lack control over it. Help me understand why you lack control over this. Under that argument, what's the idea that you lack control over this gate?
Yeah, so the lack of control here is both as a matter of statute and as a matter of contract. So pursuant to
Why can't you detour traffic?
Well, that would have been true in Wilkerson as well. In Wilkerson, the city could have detoured traffic around the obstruction.
But the court doesn't address that issue. And
It wasn't.
isn't that the obvious question that should be asked?
Well, it was impliedly not a duty of the city in Wilkerson if the court found that the city hadn't breached its obligation there. Here, the city lacks control.
Well, but so I thought what you would say to that is the fact that they have other police powers under Wilkinson's concept, right? They have nuisance powers. They have all sorts of police powers, but Wilkinson seems to stand Wilkerson seems to stand for the proposition that you must have direct control. And if you lack direct control, the fact that you might have indirect control, that is, you can shut the street down, you could bring a nuisance action, you could write them a letter and ask them to do it. Like that sort of indirect control doesn't suffice.
Absolutely, that is the clear teaching of Wilkerson and
Right, but then Wilkerson does say nowhere in the plaintiff's complaint do we find an allegation that the obstructions existed on city property. That authority is a prerequisite to responsibility. This obstruction of the railroad gate existed on city property, the public street, did it not? By crossing the public street.
Actually, the allegations here in the complaint are that the gate was on the railroad property.
Yes, but you're saying it was on city property, and we take that you know the facts in this case regarding the fact that the city is a public street.
I think the fact that it's on a city right of way doesn't make it on the city property.
Well, let's get back to this then. As the attorney for the city, are you representing that this is a public street or is not a public street? Tell us. Without any waffling, is this a public street?
I don't think it's necessary to answer that.
So you're declining to answer the question.
You answer her question.
We can assume that a street passing over a railroad
Answer her
is a
question.
public street. Yes. But
You have a duty of candor to the court.
Yes, Your Honor, a public street, it is a public street passing over the railroad.
But your point is that doesn't mean that the crossing gate is a public street because it's not on the street, it's leans down over the street.
That's correct.
And so it could be a public street, and yet the arm itself be something that you lack direct control over. That's effectively your argument.
That's correct, Your Honor, both pursuant to the statute and pursuant to the joint agreement in the record at Joint Appendix 92. Thank you.
You've saved some time. Mr. Acton?
May it please the court, I'm Bill Acton. I'm Fred DeVore and I are representing the guardians ad litem for the two minor plaintiffs who were injured in this.
Good to have you with us, sir.
Thank you very much. Just to keep things on track, I think the court would do well just to look at the district court order and start from there. It said that the plaintiff's claim arose out of the city's violation of a statutory duty to remove unnecessary obstructions from the roadway. And government immunity against such claims have been waived, and she cites 160A 296A2. And their briefs, it's all 296, much broader than A2. A2 just has to do with streets with unnecessary obstructions. Doesn't fit their argument that it's really more general than the railroad crossings discretionary statutes. She then says there's no disputed questions to the material facts. That's true. There are no disputed questions about the facts here. The railroad gate came down and obstructed Driver Street in the northbound lane of Driver Street, which was the exit lane when train arrival is imminent. Amtrak trains come through there at over 50 miles an hour. One that hit our clients were at full throttle. 50 miles, about 50.
Is that right in the middle of the city, pretty much?
It's within city limits. I'm not that familiar with Durham. It's not at downtown Durham, but it's kind of inner city, best I can tell, but you're not at downtown Durham.
That's all right.
So,
Can you turn to the argument that we were finishing with, which is, assume there is such a general duty to remove obstructions, but the North Carolina courts in Wilkerson say that duty doesn't extend to obstructions or interferences that are that the city lacks control over, right? The control is the sort of piece of the story. And the record here seems, I don't think there's a dispute about it, that based on statute and contract, the arm of the gate, once installed, is within the control of the railroad, not the city, right? And so, this is the argument that they make. In your brief, like, you don't respond to it at all. And so I just want to give you the opportunity to explain why either the city, I just want to understand your response to their argument, given that you didn't respond to it.
Let me first tell you what I think Wilkerson is saying. A couple of things. One thing's never mentioned, and then go to Hunt and some statements out of Hunt, which kind of go to the crux of your question. Wilkerson discussed, it's pled that the city violated, I think it's Durham, if I'm not mistaken, city violated a duty pursuant to 298, and the court said that's not a duty statute, it's discretion. Then it goes on to discuss the duty under 296A2. Doesn't go through this dichotomy that got nullified by 298 that they're arguing. It just said, but we can't rule with you. It said that's a good statute. They have a duty. We can't rule with you because of what Judge Keenan said. You didn't plead it right and show there was evidence of control. But what they also go back and discussing the 298 and the discretion, it says courts are not going to interfere with the city's discretionary powers or non-performance of their powers unless there's an abuse of those powers, in which case there would be liability. Well, here you've got, this was going on for 19 months. This thing was blocking traffic onto a railroad gate. And I would submit to you that is textbook discretion of their powers not to get something done. But they can get done if—
I'm sorry, I'd say that one. I'm not sure I'm following that. But so I think you agree. I mean, I get Wilkinson has two different pieces, right? There's a 298 piece and a 296 piece. And the 296 piece, they say, if you lack control, you don't have a duty, right? And I don't think that was like just a pleading point. I mean, that was a principle of law. And the point here is that railroad had control over the arm. They didn't have control over the street underneath the arm. I get that. But the arm was under the control of the railroad.
City has control over the street, and that's what the focus is.
But that wasn't true in Wilkerson, right? So the obstruction in Wilkerson was on the property of the railroad. right? And the court said, yeah, the duty applies, right? 296 applies, but because they lack control over that property, they're not bound by that duty.
Under 290,
6.
A2, because it wasn't the city's property. City, that just speaks to city streets. They have a duty to keep their streets clear of obstructions. And in Wilkerson, it neither was pled or shown that they had control over the obstruction there. As I understand it, the vegetation, correct me if I'm wrong.
Right, but the vegetation on the railroad's vegetation obstructed the road.
It was next to the railroad. I don't know if it was railroad vegetation or not. I don't know who owned it. That part I don't know, but the city couldn't.
I thought Wilkerson said it was on the railroad's property.
I don't recall that. That could be. I don't recall that. I thought it wasn't pled. It was just decided about the city. But what they did say was where it is a discretionary statute, they're not home free, even if you agree with them that 298 controls, unless you agree that they're doing nothing about that gate, obstructing that street and blocking cars on a railroad crossing for 19 months before this and exposing all those cars and the people in them and getting hit by a train is an abuse.
So I understand that. Did the district court rule on the abuse of the 298 discretion?
They just cited, they were just quoting and explaining the law. They were quoting Cooper on that.
But I'm talking about the district court below, in this case, didn't say that, yeah, they didn't say that Durham violated its discretionary duty under 298, right? It said that it violated its duty under 296.
Right. That's right.
So I'm having trouble understanding why the abuse of their discretion under 298 is relevant to this case.
My point is they're trying to show that it is they have discretion because it's a railroad arm case under 298.
No. But that's not the Wilkerson argument, right? I understand that's a separate argument.
It's in Wilkerson. I'm just pointing out that. That's all. The only reason I brought that out. That had not been pointed out before. I don't know if I'm losing you. I think
I got lost, but maybe that's my fault.
Okay. Hunt versus High Point.
Yeah, Wilkerson talks about failing to remove, that the plaintiff alleged the failure to remove a large mound of dirt, a metal building, and bushes at the crossing. It doesn't really say on whose property it was, except that we know it wasn't the city's. Do you know the record in Wilkerson to any greater detail than what the court reported here?
No, ma'am, I do not.
Okay.
That's what the case said.
Okay, well, the court was also very interested in the fact that this was a traffic improvement project that was being built out in terms of its immunity analysis. And do you draw any distinction here in the present case with the court's focus on that in Wilkerson?
You mean as far as our case?
Mm-hmm.
Because this was part of the preemption?
Yeah. In other words, is there any evidence in this record that there was any kind of improvement project, like the improvement project that was being conducted in Wilkerson, that was the subject of that litigation?
There had been an improvement and a preemption system put in place years before.
Mm-hmm. But there was no ongoing public improvement project that was underway as there was in Wilkerson. Okay.
Wasn't. In Hunt, there's some language I think may be pertinent and answer some questions. High Point argued that since Hunt is a case where a fellow fell off a bridge at night, it was dark.
Is that the Court of Appeals or the Supreme Court?
It's a Court of Appeals case, I believe. I'm sorry, Supreme Court, 226 NC 74. 1946 case in 36 Southeast 2nd 694. And if you look at 696 and 7, two things I'm going to read kind of come out of that. Let's see. High Point, it was pled that the city was negligent because this was a dangerous bridge, fellow had fallen off, and part of the danger was it was unlit, and they should have put lights up. And High Point argued that they didn't have a duty to install lights. That's discretionary, and therefore they have government immunity to that. And the Supreme Court specifically pointed out that cases stating that are confined to situations where the statute imposing the duty to maintain streets safe for travel were complied with. Here they were not. That's at 36 Southeast 2nd at 696. Then it says in North Carolina, where the planning or construction of a street or a bridge has defects, the city has government immunity. Let's see. But if the plaintiff had predicated the charge of negligence solely on the negligence in the original construction of the street, not in the breach of the incidental duty of safeguarding the danger thus created, the defendant might have relied on these cases with assurance. But the allegations in the complaint and appeal raise the question whether it was the duty of the city to provide ordinary means to alleviate the danger or avert the injury. It says North Carolina cases are uniformly against the defendant on that. That's at 36 Southeast 2nd, 695. The law is real clear. The focus is what Judge Eagles decided the motions on, and that is Durham failed its duty to keep the northbound lane of Driver Street. There's no question in any of the facts. Driver Street's a Durham street, free from obstructions. They had two choices to do it, best I can tell. They could close the street. In cases, Spies and I think Miller will say where there's discretion, and they kind of harmonize them. The court won't interfere with the discretion, but there as to the means as to keeping the street safe. But the duty to keep the street safe is never waived, and it never goes away because the duty is to the people using those streets. And so Durham had two options, seems to me, to keep it safe. Close the street as long as that danger's there. For 19 months, they didn't do that. They let it go. The only other option is to use 298 and the discretionary statutes and just get on the phone and tell Norfolk Southern, replace your gate. You're blocking our traffic, which they would have.
What about the idea that if they just cut the gates off, right? So like a traffic light, instead of blocking the street off, they just opened all the gates. And they said, since they're defective, we've got to open them all. And I get that might create some danger, but there wouldn't be an obstruction anymore, right?
Who are you asking me? Is Durham doing that or?
Sure. I mean, I don't know that they've got the authority to do that, but let's assume for a minute that they do, right? Do they unplug them, right? So imagine there's just a plug. I know there's not, but.
Yes, to answer your question is, I guess the obstructions would be gone, but they still have a duty to maintain the street safe for the travelers, and that would be inherently.
Right, but that'd be like the stoplights that stop working.
That'd be a worse situation.
Right. I mean,
Nobody wants that.
Duty, but just not the specific one that this case is involved. I don't think that's an option for them. Go ahead. Okay. I think Mr. DeVore wants to correct it.
Mr. DeVore? Now you're representing the same clients.
I do, Your Honor.
Y'all sharing the argument.
We are, and I have just a brief argument.
Well, it's good to have you here as well, sir.
Thank you. Some people refer to me as an old country lawyer, and I don't know whether that's true or not. Old is true, but
welcome to the Fourth Circuit. We need some good country lawyers.
I try to make cases as simple as I can make them to understand them for me. And so what I did in this particular case is I found the 4 facts that are not in dispute. And I want to begin with those 4 things. And then I want to give you an illustration that I think addresses both Judge Keenan and Judge Richardson's issues with Wilkerson. I think I can explain that. So what we know is, and although it took a while to get there, the Driver Street is a city street of Durham. There is no question about that. It's admitted in the pleadings. It's admitted throughout the record. That's not an issue. Number 2, it's also known and admitted that 19 months prior to the crash, Durham inspected that railroad crossing, and they did so pursuant to a preemption agreement that requires them to inspect the gate with a train coming through. There's no documentation they did that, but 19 months earlier, they took photographs even of the elongated gate, gate E, on the northbound lane. So that's admitted. The third admitted fact is that when the gate was lowered, that is gate E, the northbound gate, it obstructed cars from getting off the tracks. And so that you understand, Judge Richardson, your question about all the just raise all the arms up. There are 3 sets of railroad tracks go through there. 2 at least, or at least one of which is a high-speed Amtrak track that Mr. Acton did.
Oh, I'm not saying it'd be a good idea. Let me be very clear, right? I'm just asking whether, like, that's the point of hypotheticals, right? I'm not suggesting to sit, make note of this, Durham. I'm not suggesting you do this.
It would
right.
do obstruction. There's no question about
Right.
that.
But my point was it would eliminate the obstruction.
As Judge King said, then we open an entire another whole issue with in terms of the liability and the dangerousness. And then
what's your third fact again?
the third fact is that when they lowered the gate, gate E obstructed the cars. And in this case, it was 3 cars actually that could not get around the gate. And the last one being, unfortunately, the vehicle that Mr. Hyman was driving. And then the fourth point that seems undisputed is the language that's found in 160-296, A2. And it imposes a mandatory non-delegable duty to remove obstructions. Now, if you agree with those 4 premises, so those 4 things, which I think are not disputed, then I want to give you an illustration that I think addresses Wilkerson. Assume for the purposes of this argument, there's a large tree that's located beside the road, but not on the city's property. The limbs perhaps extend over the road, up in the air, but the tree itself is not on city property. The city might have the discretion to limb up those limbs that come over the road, but they don't have the discretion or the ability or the authority to cut down that tree. Now, assume for purpose of this illustration that the tree then falls down, falls from the other owner's property across the road and creates an obstruction. When that occurs, then you assume that the city has inspected the road and sees the tree down across. They see the obstruction, just like Durham did 19 months earlier. Then the question becomes, what then is the duty? And as Mr. Acton aptly said earlier, there are 2 things that could happen. One is that you could remove the obstruction. Now, you may be able to go back later and bill the homeowner, the landowner for a defective tree or something. But the duty at that moment is to remove the obstruction. And if they can't remove the obstruction for whatever reasons, they don't have the equipment, the tree is too large, it takes too long, whatever it is, then there's an absolute duty to close the street. What is missing, however, is there is not a duty to do nothing. And the failure of Durham to do anything, to stick their head in the sand, that's the problem in this case, right? That you just can't do nothing. Once you have discovered the problem, then you simply have got to make the effort to either make those streets safe for the people that use them, safe for the kids in the back of the rear of the pickup truck that were hit in this case. That's the duty that Durham violated, just as Judge Eagles found.
So can you help me understand that hypothetical? Because the hypothetical you give, in Wilkerson, what it says is there's not a duty of an area that was controlled by the railroad, right? That's the Wilkerson principle. And so I get that when the tree falls in the road because it's now on the property of the city, right? It's in the road. But the challenge we have here is that this railroad gate didn't fall. Had it fallen off the hinges and landed on the road, it's an obstruction. I'm with you. It's above the road, and by contract and by statute, when it is above the road, it is controlled by the railroad. Like that's the trouble. Do you see the trouble I'm having?
Issue though is the road itself. I mean the arm itself, the gate, is at the height that prevents cars from going. So whether it's laying on the ground or whether it's 6 inches off the ground or whether it's 3 feet off the ground, as this one was, it obstructs the traffic from going off.
So I agree it's an obstruction. I'm really trying to understand. I mean, I'm not totally sure Wilkerson makes sense, right? But I'm just trying to apply it, right? Our job, as Judge King mentioned, is just to try to apply the law that we've got, right? And so I guess what I'm trying to figure out is like how I say it's within the control of the city, which Wilkerson contrasts with an area that's controlled by the railroad.
May I answer it a little bit over time?
Please.
Well, you go right ahead. As long as you get questions, you keep answering.
Thank you, Judge. If the arm is in the air and the arm is on the railroad property, I would probably concede Durham has nothing they can do about that. But once that arm comes down, crosses the city street, creates the obstruction, that's where the duty arises. That's where Durham has got to either close the street or they've got to do something to get their obstruction removed.
It's effectively like the tree is fallen. That's what the fact that it's 3 feet off the ground doesn't make a difference is the idea.
Correct. We respectfully therefore ask the court to affirm the decision of Judge Eagles, find that Durham has violated its statutory duty to keep streets free from obstructions, and by doing so, refuse to excuse Durham's negligence on the basis of governmental immunity. This will allow these catastrophically injured children their day in court. Thank you very much.
Thank you, sir. Mr. Church, you've saved some time.
Thank you.
Can you start with this last idea? Because I'm still struggling, obviously. So I assume you agree if the tree falls in the road, it's an obstruction and the city has to remove it. And so help me understand why that doesn't answer the question here, because the arm goes across, the city's property runs to the sky, right? We often say that in property law. And so once it's 3 feet off the ground, it doesn't matter that it hit the ground or not. It's like the tree in the road.
So Judge Richardson, I agreed initially with your distinction that the tree, when it falls on the road, it is now within the city's, it's on the city's property, it's within the police powers. When the crossing gate goes down under its normal operation, that doesn't change the character pursuant to statute and joint agreement, and the joint agreement that it is still within the railroad company's full custody and control, both under the railroad crossing statute and under the joint agreements.
Can the city contractually delegate its duty? So assume it has a duty. Can it enter a contract with the railroad to say, if this tree falls in the road, it's your responsibility to remove it?
So the North Carolina Court of Appeals decision in Steele versus Durham suggests that it could. So the city of Durham and Steele argued in that case that it shouldn't be liable for a hole in a sidewalk. And the court in Steele actually said, if you had delegated by contract to the Department of Transportation, this might have worked, but you didn't. So the court in Steele actually said that might work. Here, I would go even further and say we don't need a contract because we also have a statute that says the maintenance is to be performed by the railroad. So I know if I do have a contract, but I also have a statute that doubles up that and says the maintenance is to be performed by the railroad. So I don't even have to answer the question about whether a contract is sufficient, but the Court of Appeals in Steele has said in the case that you could delegate that as a matter of fact. Earlier in my friend's
let me ask you a question. We're talking about the bouncing around with these North Carolina cases. This is all state law. And the Court of Appeals of North Carolina is the intermediate court of the state. And their rulings are what kind of precedent as to being state law? And because Wilkinson, whatever it is. And in this case, the other case you just mentioned are Court of Appeals decisions.
That's correct. So they're not from the highest court, but given that they are.
But what's the principle of law in North Carolina as to whether they're binding or not, or controlling?
I wouldn't say that they're controlling,
Okay.
but given their consistency, there would be no reason for the court to disregard them here.
So, but the North Carolina Supreme Court's rulings are the law of the state.
That's correct.
Court of Appeals rulings are not necessarily the law of the state.
That's correct. And there's nothing in Wilkerson that's inconsistent with Supreme Court law on these issues. It was discussed here about, what if the city of Durham simply raised the gates or had the gates raised or eliminated them? Isn't that an option? In fact, that is an option. And I think we all agreed in the courtroom, that's a bad option, but it is expressly an option under the statute. And that's a public policy implication that this panel has to consider here when we say we're not going to treat railroad crossing gates like other traffic control devices. The statutes expressly authorize but do not obligate cities to require their installation. And so both Cooper and Wilkerson held that a city is completely immune from its decisions about whether to require their installation. And in fact, in Wilkerson, both in Wilkerson and Cooper, the courts there held that the failure to install warning gates and bells and whistles at railroad crossings was an issue for which the city was immune.
Right, but that's the exercise of the city's discretionary authority to determine what traffic control devices are required. That's distinct from keeping the ones that are in existence from creating an unnecessary obstruction to the street. And that's the distinction here that I'm not sure you're addressing.
Well, it is. There is the point that I'm making there is there's no reason to treat those crossing gates any differently than other forms of traffic control.
Because the traffic control devices are not obstructions.
Any malfunctioning traffic control device is an obstruction.
How does it obstruct? How does it limit movement? How does a non-functioning traffic signal keep people from driving?
Within Cooper defines an obstruction to be anything that makes the public passage less safe and secure. And in that definition, anything that malfunctions is an obstruction within the meaning of Cooper.
Well, let's get to the language of Cooper here, because I'm not sure Cooper says, let's take a look. I've got all these cases stacked up. Okay, Cooper says an unnecessary obstruction can be anything which renders the public passageway, anything which renders the public passageway less safe or convenient for use. And in that case, the issue was the failure to install automatic signals, right?
That's right.
So,
and so I would say, again, any malfunctioning traffic control signal would qualify as an obstruction under Cooper's definition. And so we can't square Cooper with the general immunity for the installation, maintenance, and an operation of traffic.
Right, but the court was relying on the discretion afforded the city by Section 298 to exercise its discretion in requiring improvements. So that's the discretionary exercise of authority by the city. Do we need this kind of traffic control device? That was what was at issue in Cooper, okay? Here, we have a decision's already been made. We need a crossing gate. And then the issue is, do we have to do anything about something that prevents movement on the public street? So it's a different issue. Cooper was talking about the discretionary authority and, excuse me, and the discretionary duty to exercise a decision-making power to install that kind of a device.
And once installed, here the plaintiffs affirmatively argue that it is a traffic control.
But that's the essence of the immunity determination. If the city is making a discretionary determination whether to install a device, that is an exercise, a legitimate exercise of governmental authority. That is not inconsistent with the duty to keep the streets safe.
And the court in Kusina said once installed, the operation and maintenance of those devices continues to be accorded governmental immunity.
Well, the court in Kusina didn't like what it was doing, right? It was concerned with whether they had to follow this ruling in Roop, right?
It did, Your Honor.
Okay. What was at issue in Kusina?
Kusina was a fallen stop sign.
It was right. Mm-hmm. And it wasn't obstructing the road. So again, you have a traffic control device that was inoperable, but not obstructing the public street. So I don't think your case is on point.
It was obstructing within the meaning of Cooper by making the passage less secure, less safe and convenient.
Mr. Church?
Thank you, Your Honor.
Appreciate it very much. Thank you. I want to particularly mention to you that if we didn't have this pandemic restrictions still going on, we would leave the bench at this point and come down to the well of the court and greet you lawyers from North Carolina and tell you what a fine job you did. shake your hand. We'll just have to take that from the bench and defer the handshake until the next time you're up here. And I should mention, my friend Judge Paul Niemeyer, when he presides over panels, he always, or not always, but most of the time, he mentions that tradition of the Fourth Circuit to shake hands with the lawyers was initiated by Judge John J. Parker, Chief Judge of the Fourth Circuit back in the early 1930s. And Judge John J. Parker, if I recall, was before he came on the Fourth Circuit, was a lawyer in Charlotte, a native of North Carolina. So the tradition, you're in the tradition in many ways. And we really appreciate you, and look forward to having you back.
Thank you. Thank you, Judge. Thank you.
We'll take a brief recess, Madam Clerk. Mr. Largus,
Right here, Your Honor. Thank you very much. Good morning.
good to have you with us, sir.
Pleasure to be here. Thank you for the opportunity. We're here on a grant of summary judgment to the defendant. So obviously the settled question is, were there any facts in this record for a trial? This case is unusual in that there are so many videos.
And this was an interlocutory appeal.
No, this is
It's not.
grant of summary judgment,
Pardon? No, no, okay.
final decision, grant of summary judgment.
Well, it's on there on qualified immunity.
No, sir. On the merits.
Because of reasonableness point. Okay.
And all the state law claims are dismissed as well. So it's
Okay. Yes, sir. I'm with you now.
here,
This is from Judge Conrad.
or Judge Conrad, or non-Spanish speaking officers respond to a
So
call.
just so I understand, so your position is we only have the merits if we also have qualified immunity.
Yes.
That's what I thought.
It was all based on qualified immunity,
It's-
but it's not an interlocutory
based
appeal.
both.
you're saying.
It's on both.
Okay, I'm sorry. I thought I misunderstood what you were saying. It's both. We have both before us, and under our sort of two-step, we could decide on either ground. Okay.
So the question is there a dispute about the reasonableness of the shooting? And in fact, is these recent cases, Nibbs and Hensley, was there an immediate threat that justified the shooting? So you have 4 officers respond, deciding not to wait for a Spanish speaking officer, to a gentleman who's called the Spanish line and asked for a Spanish officer to come help him surrender a gun. It's a bizarre series of phone conversations. The gentleman's paranoid, mentally ill. But the officers don't wait, and when they arrive, they each have a body camera. And those 4 body cameras, and
How many times did the lady with the 911 calls tell him to surrender or come out without the gun?
I think that Judge Conrad counted 6. I don't dispute that, and I don't think that's the dispositive issue in the
I
case.
didn't say it was this way. I'm asking you the facts.
Right.
Don't get the facts
But
straight.
what the videos show, Your Honor,
But the videos, and there are 4 videos.
there are more than 4. There
More
are
than 4, okay.
4 at the scene. The body cameras at the
Okay.
scene show this kind of disturbing image of a gentleman with both hands up in the air like this as he is gunned down.
Now, are you referring to Officer Tran Thompson's
Yeah.
video?
Trans Thompson's, which is at,
Okay.
I can give you the site.
No, that's
His-
okay.
The clip is at 2016, which is the easiest one to look at. It's about 1 minute and 20 seconds long. But you can see at the end of that, he has his hands up. Then at 20-1 is this composite video, and it shows from the perspective of all 4 officers are kind of put into a clip. And the 2 officers who are on the other side of the building from where Guerra is standing, they can see that he's holding the gun upside down. And the video shows that, and Judge Conrad found that. One of those.
But I mean, I take that we agree that angle is not what the officer, the defendant could see. We can't understand that that's what he saw. He's seeing it from a different angle.
But listen to what Judge Conrad and the defendants have omitted, Your Honor. And that is the next clip that you see is the interview of Tran Thompson, who's behind Guerra. And he describes the exact same position of the glove. Batson says he's holding it like this, dropped down from his hand.
Which hand is he holding it in?
He's holding it in his left.
Okay, you were holding up your
I
right.
apologize. If you're Guerra, he's
Now
holding
he's
it.
holding it. You're trying to explain how he's holding it. Now, both of the experts, according to what I read, said, well, he could have fired it as he was holding it.
In
And you're emphasizing, and I think he did in your papers and everything as well, the way he was holding the firearm. But both of the experts, your expert and their expert, apparently basically agreed that you can fire a gun when you're holding it upside down.
But what he said is,
Isn't that right?
but it's a,
Answer my question.
it is, it's a potential threat, but is it an immediate threat is the question. And the rest of the video show that it was not. If this is the gun and this is the barrel away from my hand, Your Honor, he's holding it like this and you are Guerra. So not only is the hand away from you, but the gun is.
On his video, that can't be seen.
Oh, no, Tran Thompson can see that he's holding the gun like this.
But Tran Thompson was not the officer.
He's
that fired.
behind the officer, directly behind.
No, he's not directly. He's off to the left.
He might.
The officer who's
agrees
the
to the left.
video of the officer who fired is blocked by the edge of the apartment building.
Right,
There you go.
which shows how
You
much.
can see part of one hand and not the other hand, not the left hand. You can see part of the right, or part of the right arm, I think.
But you can.
I'm no expert, but these experts and particularly and Judge Conrad looked at those videos too. Because we were reviewing that.
Judge Conrad never mentioned Tran Thompson's video in his order, Your Honor. Never. And instead, he found that it was impossible, that he found that Guerra could not see that the gun was not positioned the way that Batson said it, but he could see the way that Tran Thompson could see it from even farther away. That's a material issue of fact in this case. And an improper finding of fact to say that the video proves in this case that Guerra could not see the gun. Guerra describes the gun in intimate detail and describes having a pistol grip hand, his hand in a pistol grip.
I'm talking about what the video showed.
Exactly.
Maybe he did see the gun, but according to the video, doesn't show the gun. The video taken by Guerra doesn't show the gun.
No, it doesn't. But
All right.
but the video by Tran Thompson, who is at the roughly same angle, not exactly, but
Okay, Mr. Largess, I'm sorry, I didn't mean to interrupt you.
no, go ahead, Your Honor.
I think your argument would be more helpful perhaps for the court if you could discuss for us what facts are in dispute and whether the trial court resolved any of those disputed facts in reaching its determination on summary judgment. In other words, went outside the mandate of the summary judgment rule. So what are the disputed facts in the case? And did the trial court resolve any of those in favor of the defendant
Did, Your Honor.
improperly?
At least several. And the first is what we were getting at here. The court declares what Guerra cannot see. That's a disputed issue of fact in this case. Guerra, 2 days later, on video, comes in and demonstrates this remarkably different encounter from what you see in the Tran Thompson video. If you look at those two videos, and the clips are at, I'm sorry, 2032 and 2033. He says that Galindo came out with both hands up and kept his right hand up the whole time, which clearly didn't happen. Drops his left hand down and takes the gun out and then points it at him like this, like I'm pointing at you right now, Judge King, and that's why he shot him. The video shows that that never happened. That conflict right there is the fundamental factual dispute in this case that the judge didn't even address, let alone. Instead, what Judge Conrad did, he chastised us for pointing out that remarkably different version of events.
Well, the judge found that Galindo reached into his pocket for a gun. That's in
which is
the discussion at pages 10 to 12 of his opinion.
right, but not that he had his hands up and reached down from a hand up position and pulled it out. And there's a question of fact as to whether he pulled it out of his pocket.
Right. Well, I guess I'm trying to tell you this is a friendly question. The judge said instead of raising his hands in response to Officer Guerra's Manos command, Galindo reached into his pocket for a gun. Now, could you tell us whether those facts were in dispute?
What's in dispute in that regard is that when he came out and yelled Manos, Mr. Galindo, who's just come off the phone with the translator and said, tell me, I'll throw it down. Tell me how I should display the gun. And he comes out and he hesitates putting it up and then puts it up fully as Officer Guerra with his one hand says, Manos, Manos. he holds up his one hand. And then when they start yelling at him in English to drop the gun, he puts up the other hand. And the judge finds that he refused the English command to drop the weapon. Can you imagine if the officers gave a native English speaker commands in Spanish to drop a weapon for 3 seconds and then shot him for not complying?
Okay, that's a good jury argument, but you've got to convince us that lay out for us what the disputed facts were that warranted your going to trial.
Well, the disputed facts are whether he in fact failed to follow commands, whether in fact.
But isn't the question, I guess I'm having a little trouble there, right? So, I mean, there's no doubt he did fail to follow the command. The question is, why did he fail to follow the command? One, and the officer testified, and I think reasonably, that even people who speak Spanish that live in America understand some English. And so, I took that to sort of effectively mean that I believe he understood drop the gun, right? Even if maybe he couldn't have had a discussion about, the causes of inflation and what we're doing to resolve it.
I think that's a question of fact, Your Honor. Is someone in a crisis like that with 4 people yelling in a foreign language to him, drop it, put it down, drop it, put it down? What if, and that's why I'm saying the analogy.
Wait, but why is that a question of fact? Because what I said was there's no question of fact that he did not comply with the command, right? And is also, there is no way for us to know why he did not comply with the command, right? Because the only person who knows that information is dead. And so what's the disputed fact there? Right? You wanted to focus. I just was trying to get at your focus. Your focus was it's unreasonable to say that he didn't comply with the command when we know he didn't comply with the command. The question is why, but there's no dispute about that because there's no position on it one way or the other. All we know is he didn't comply.
Okay, well, I hear what I hear you. My perspective on it's a little different, but I hear you. But the other issue is he then says this is a split-second decision. And it was, but the question there is that goes to essentially to the reasonableness of the shooting. These officers are all behind cover. And though this man has not dropped this gun, he's holding it in a completely harmless position. And there were 2 experts on our side, and one of them got convinced to say, yeah, it's in theory, you can fire a gun with a pinky, but he would have to turn the gun upside down and point it. He's holding it over here. And so why not wait? You have cases in this district where people who are armed and the officers wait 7 hours.
How many seconds did they have to deal with this fella? With the gun in his hand?
As much as they wanted.
How many? Well, no, but the video is 6 or 8 seconds long. You say that's all covered right there.
He's behind cover the entire time.
Oh, you're going back and saying the only thing they could do was how they're going to wait 7 hours before they go out to the house?
What I'm saying is that you have cases
when they get this call.
You have cases where people
they're responding to people in trouble.
He's responding to someone who has to turn in a weapon. And you have cases where someone who's committed a crime is being pursued.
And we give deference to these police officers.
Right?
We give deference to them.
I know you do.
I mean, the Supreme Court said, we don't use 2020 look back, right?
But you can't.
In gray areas, what are the language about that?
But here is the final dispute.
I mean, that's what this qualified immunity is all about. Did they act reasonably?
Exactly, Your Honor.
Did they act reasonably?
Can I ask this? Because you just said that he called. I'm having a little hard time understanding whether the facts you're giving me are really the facts, because you just said, and I didn't understand this to be true, that he called asking to turn in a gun. Tell me where in the record, where do I find that piece of the record?
In the translation of the first call, he's explaining, I have a gun. I want to surrender it. I have a court date. I want to surrender. People are following me. And then when he says to the translator in the second call that I'm not going to leave the gun in the house. I have it in the bag. If it's better to take it out, tell me how. I will throw it down. Tell me how you want me to show it to them. So they know.
And they say, leave it in the house. And he refuses.
And the mentally ill man refuses. And then he comes out and he's standing erect with his hands up when he's killed by officers behind cover. But here's the final disputed issue of fact. And this is, I think, the Jacobs issue in this case.
He called and asked for help.
For help.
Is that right? He asked for help more than once. He said he was calling for help. And then he said he had a gun. I have a gun. I need help. I have a gun.
I can go through the transcript carefully and send you an addendum of every place where he mentions the gun, Your Honor. But I think that it's clear they knew he had a gun, and
the question is, there's no doubt he has a gun. The question is, did he call asking to turn in the gun? He mentions a gun. I don't deny that. I didn't understand it the way you characterized it, but I can go back and read it. I don't need you to point it out. I don't mean to take him over, Judge. I'm sorry.
He has a court date, Your Honor.
No.
That week for assault by pointing the weapon. He's trying to surrender the gun.
He called to ask for help and turn himself in. And he said, I have a gun during the course of the discussion. And the dispatcher, you said, you accepted, told him 6 times not to come out with the gun.
And clearly that creates a dangerous situation.
That was before they went out there.
Exactly.
The dispatcher told him 6 times, don't come with the gun.
He goes out with the gun. They know he's coming out with the gun. He claims there's no bullets. But here's the finding of fact that I want to get to. Judge Conrad, rather than trying to address the discrepancy between the way Guerra justified the shooting by saying he pointed the gun at me, that was the immediate threat he gave. He says that when he had his hands up like this, his left hand began to drop before he was shot. Look at that video. There's no way that you can make a finding like that. That's the threat that Judge Conrad created to justify the shooting, that he dropped his hand at the end. And now the defendants try to piggyback on that and try to somehow tie that to the perception that Guerra had, but Guerra never said that. We showed them the video, and they both he and Trent Thompson said, you don't see the hand move until he's shot. And both hands come down at the same time. But that's the basis for finding the immediate threat. And that's improper fact-finding. I've gone well over my time.
As long as you have questions, you can answer, as far as I'm concerned. You save some time. Ms. Keaton?
May it please the court, Your Honor.
Good to have you with us, Ms. Keaton.
For having me. Oh, sorry. I had to be reminded I could take off my mask.
Yeah, take that mask off.
Yesterday I messed up the clock. Today I messed up the mask. Let's hope those are my only bad mistakes. Your Honor, I represent Officer David Guerra in this matter. And if I may, I would like to pick up where you all left off momentarily with some of your questions. One thing that was mentioned in Mr. Largessa's argument, you all asked about whether Trent Thompson's video was mentioned in Judge Conrad's opinion. Your Honors, I would point you to the fact that he does in fact mention Trent Thompson's video in footnote 2 on page 5. He specifically says that he says that the footage from Trent Thompson's body-worn camera would most accurately capture the scene as Guerra would have experienced it. So he did, in fact, specifically say that.
I think he's talking about the video of the interview, not the body cam video. I think when he referred to Trent Thompson's video not being mentioned, I took him not to be referring to his body cam video, but instead to the interview, right, where Trent Thompson says, "I saw the gun dangling." Interview.
Okay, I understood. But he does say that he relied on the body-worn camera footage, and he took the facts in the light most favorable to the plaintiff, just as you were supposed to do at summary judgment. We don't dispute that that's the standard here. And he specifically does talk about, very specifically in that footnote, that the evidence was looked at most favorable to the plaintiff, and they relied on the video footage. But we do have the issue that your honors have appropriately pointed out, and that is the fact that you cannot utilize the body-worn camera from the standpoint which Officer Guerra could not see. The best we have is we do have Guerra's body worn camera, and then we have Tran Thompson, who was approximately 10 feet away to the left. And I would note with regards to Tran Thompson, since it's come up, the idea that, you know, his perspective and what he said in his interview, he also said that he flipped the safety mechanism off of his rifle and began to move his finger to the trigger. And that's in the record and the joint appendix. So I would say that he too perceived a threat here. And I think that Your Honor's appropriately focused in on the fact here that the
Do we have to state for this, for the record that we've got, taking the facts in the light most favorable, that given Tran Thompson's interview and his positioning relative to the defendant, that, you know, an officer in the defendant's position could see that the gun was being held in a manner inconsistent with the way the defendant described it?
I think the key here is the objective, a reasonable officer in Guerra's position, and we do not look at subjective intent.
We don't look at subjective intent, right? But what we do say is we have objective evidence that the gun was in fact, sorry, I'll use my left hand, right? That the gun was in fact held in a dangling manner, not high and tight, right? I mean, we have video that we know that was true, right? From the other angle, right? Second, we have Tran Thompson, who is in the same line of sight behind the defendant, and he sees that the gun is hanging in some manner. In other words, not high and tight. And so I guess what I'm asking is, given those two pieces of information, right? A, that it's objectively true that it was not high and tight, it was hanging, and that another officer perceived the hanging in the same, you know, visual sight line as the defendant, that is in fact what the defendant saw, right? Not that his subjective beliefs, right? But the like perceptions we have to look at from what a reasonable officer would have seen. And Tran Thompson seems like, at least in the light most favorable to the defendant, that perspective.
And
am I getting that right?
I understand what you're saying, Your Honor. I think you are, in terms of a reasonable officer who was standing where Tran Thompson was, would have seen that. And that is how I would interpret it. And I think what matters here is, as you all are well aware, we look at the totality of the circumstances. So we don't just take the segmented view of, at that moment, the gun was held upside down. And even though the experts acknowledge it could be shot that way, that it was held upside down. But what we have to keep in mind is it's being held after he's been told in his native language 6 times to leave the gun inside and to show his hands. He was told that in Spanish as well before he walks out into the apartment complex of 200 to 400 people. And so
But what about the fact, though, Ms. Keaton, that the trial court seemed to be resolving the case in the light, stating the facts in the light most favorable to the defendant? I mean, the trial court said that instead of raising his hands in response, the court found this as the single most compelling fact. He said this on page 12, that instead of raising his hands in response to Officer Guerra's Manos command, Galindo reached into his pocket for a gun. Now, that's a disputed fact, isn't it? Whether he reached into his pocket for a gun. And then the district court says in another place that it relied on the video to resolve any conflicts in the evidence. So what worries me in this case is a jury might very well find for the officer, but it looks like the trial court stepped into the role of fact finder to resolve disputed facts here by saying that that Galindo, the decedent, reached into his pocket for a gun. That's disputed, isn't it?
I don't believe that is disputed, Your Honor. And I think that even if regardless of whether he reached, the point is that he had been told to leave the gun inside.
Can you go back to that point? I'm actually curious to the answer to that question before you go back to leave the gun inside. Help me under why is it not disputed? I mean, I think I might agree with you again in the nature of this is, I think, a friendly question. Why is it disputed? Is there any evidence that he did not reach into his pocket? I mean, the video seems to show that. The several officers testified to it. Is there, and maybe there is there testimony to the contrary that he never reached into his pocket and got the gun?
There is not, Your Honor.
Is there testimony that when he came out the door, he had the gun in his hand already?
No, Your Honor. And the fact is, he was told Manos, Manos. He shows his hands and then he reaches back down and gets the gun. And so he was definitely defying the commands he'd been given. And I would say it's not a disputed fact because it's no different than the cases where this court has frequently had to make determinations and found that qualified immunity applied. For instance, you all have looked at, okay, this person was reaching, they thought it was a
Come
gun.
back to Judge Keenan's
Oh, I'm
question.
sorry. So, Your Honor, I'm sorry if I didn't finish answering your question.
Yeah,
I do not believe it's a disputed
Yeah,
fact, Your Honor.
Yeah, I guess it's when the court's saying on the page 13 of its opinion, to the extent there is discrepancy between Officer Guerra's testimony and the video footage, the court relies on the video footage, especially that taken by Officer Tran Thompson's body camera. So I'm just wondering if I'm worried in this case that perhaps the court entered into the role of fact finder. The court saying, well, the evidence, to the extent there may be a discrepancy, suggesting there may be, I resolved it by looking at the Tran Thompson video. So is that the role of the trial court on summary judgment?
And I think, Your Honor, looking at the body worn camera when it's not just when there isn't a disputed fact and going by what the camera shows is the appropriate method to handle that. So that is, I think, exactly what he did here. I think that he looked at.
Do we have cases that effectively say that on summary judgment where there's indisputable video, like video evidence, that a contrary statement does not raise a material issue of fact? I mean, if, for example, somebody said Superman flew down into the screen, we wouldn't think that's a disputed fact. So it seems hard given that there's a video. If it's not on the video, it's one thing, but if it's on the video, doesn't that mean it's not disputed?
Right, Your Honor. And I think the case that plaintiff actually cites too that's helpful on this point is Scott v. Harris. And in that case, they talk about the fact that there was a motion for summary judgment that raised factual issues about whether a motorist was fleeing law enforcement officials and was he driving in such a fashion as to endanger human life at the time that the deputy rammed the motorist's car from behind to put an end to the chase. And the Supreme Court determined there that the motorist version of events was so utterly discredited by the record that the jury could not have believed him. And thus the court should have viewed the facts in the light depicted by the videotape rather than the motorist testimony. So I guess what I'm saying here is, to the extent you think that his testimony is not credible or it's been discredited, then Scott teaches us that you view the facts in the light depicted by the videotape. So that is Scott v. Harris, 530 U.S. 372. So I believe that is exactly what was done here, is we relied upon the video if there was any question of fact.
But the video was really ambiguous as to whether he reached into his pocket. I mean, I looked at the video. You couldn't tell whether he reached into his pocket. Yet the court said he reached into his pocket.
And so I understand that is your position. And so
well, no, it's not my position. I looked at the video really carefully, and the video did not show him reaching into a pocket. The video showed his hand going down. Now, and the court's saying he reached into his pocket. So you're saying the court can just put all this together? And I'm just worried about the jury's role and the court's role. And it's a tragic case, and I just want to make sure that the court didn't step over into the jury box.
And it is a tragic case, Your Honor. And I would certainly say then to finish my argument out, we can certainly assume for the purposes of this record, let's assume that the evidence in light most favorable to the plaintiff, that he didn't reach in his pocket, that he had the gun in his hand. There's no dispute he had a gun. Like many of the cases that are cited before in the briefs, the person ended up not having a gun. It's undisputed he had a gun in his hand. It's undisputed he was told to leave it inside 6 times in his native language, to come out with his arms up. It is undisputed that he raised his arms. The plaintiff wants to suggest that raising your arms up is the universal position of surrender. It is undisputed that he raises his arms up with that gun in his hand. That portion is not disputed, whether he has
dangling in his hand.
with it dangling in his hand. And so that portion is not disputed. And so I would say, Your Honor, that the whole purpose of qualified immunity is that we don't sit here and judge the conduct of the officer with the benefit of hindsight, but we consider would a reasonable officer in that position who goes to a call after 2 911 calls of someone who is delusional, who's been drinking, who has a prior charge for pointing a weapon of which the officer is aware, who has been uncooperative with the dispatchers, and then he comes out the door and he has the gun in his hand, and then Officer Guerra doesn't shoot right away, which, I mean, as we all know, the Fourth Circuit is clear. Possession of a weapon in itself is not a reason to shoot someone. That's not what we have here. He then is told manos, manos, and he raises his hand and he keeps the gun in his hand throughout the encounter. And then at the very end, as he's shot, he appears to be dropping it. So again, we need to make room for, if Your Honor believes this is a mistake, I would say the question then is not, this needs to go to a jury. We need to determine if qualified immunity applies here. And we know that qualified immunity, the whole purpose is to give officers the benefit of the doubt in situations such as this that are tense and rapidly evolving. And that is exactly what we had here on this night.
Can the plaintiff overcome the qualified immunity claim through his expert report?
I don't believe he can, Your Honor. It's interesting you bring up his expert report. His expert says, his expert makes the point, Mel Tucker, he makes his whole opinion is premised around the notion that Mr. Galindo never pointed his gun at the officer, and thus the use of force was inappropriate.
And you had an expert that gave a different opinion.
Interestingly enough.
But for the purposes of summary judgment, the court would need to accept his expert report. Isn't that right?
I think that you would take both expert reports into consideration, but if it's a disputed fact, then they get the benefit of the doubt. But in this case, again, I do think
they dispute each other. I mean, the experts give different views, two different opinions.
They do, but to the extent that his expert gives an opinion that goes against Fourth Circuit established law, I don't think this court.
What about that case that we had?
Nibs?
That just came out. One y'all relied on in your brief and got.
I relied
on you before they got to their reply brief.
Don't wait a few weeks. In Nibs, Your Honor.
Didn't expect that, did you?
Wasn't expecting that twist of
events. How are you going to deal with that?
I'm so glad you asked. In Nibs, Your Honor, I relied on it for two propositions, and that is that even though no serious crime was committed, it did not negate the fact that the force was reasonable. And I think that proposition applies separate and apart from Nibs. I don't think I need Nibs for the proposition that the severity of the crime, just because it's not a severe crime, does not necessarily mean the officer doesn't need to use deadly force, ultimately, depending on what happens at the call. The second thing that I relied on Nibs for was saying that even if the officer misperceived the gun was directed at him, the deputy did not have to actually detect that Nibs was aiming and pulling the trigger in order to be able to shoot. And I think, Your Honor, the important thing there is,
but now Nibs has been rebirthed.
It has, but fortunately.
So how are you going to, how you get around the Nibs if that's right to pronounce it, the Fourth Circuit Nibs?
I get around it because
Judge Agee's opinion.
In that case, the two propositions for which I cited are also stated in Sigmund v. Chapel Hill and in McClinigan. So it is still true that even if the person is not pointing the gun at you, you can still use deadly force. And so that was the portion of Nibs that I utilized. It's also important to note that in Nibs, there was no body-worn camera footage. I will also.
Can I ask, so I thought what you would say, because I thought we were talking about qualified immunity, I thought what you'd say is that when we look at whether the law is clearly established, we got to do it at the time, and that's in 2017. And so that we can't, for clearly established law, we can't look at Nibs, we can't look at Benton, we can't look at Hensley, which is decided several months after this particular incident. So all of, in those cases, are quite helpful to the plaintiff on the merits, but we can't look at any of those for determining whether the law is clearly established, right?
Yes, you're correct on that.
Because we have to look at the law at the time of the shoot.
That is correct. And even with
and the district court didn't assess the clearly established question. He didn't get there.
Correct. They didn't need to get there.
Because there's no constitutional violation.
That's correct, Your Honor. And on the clearly established point, I would suggest that this court, even if there's a disputed fact, can still make a determination on the clearly established point because that's a matter of law. And so that is something this court could choose to uphold the decision based upon, that he was entitled to qualified immunity because it was not clearly established at this point in time that an officer is.
What would, if you're going to say that, give us specifically, I know you were about to do it, I think.
Okay.
What's the point that wasn't clearly established?
I would say, Your Honor, that at the time of this incident, it was not clearly established that an officer is forbidden to utilize deadly force when he is faced with someone who has disobeyed commands and who is holding that gun in a manner in which it can be shot. And so I think that when you look at the exact question, and as we know from recent Supreme Court decisions, it has to be looked at in a very detailed manner. It's not just the general right of you can be free from excessive force. It has to be much more specific than that. And so in this case, you would have to look at the fact that the officer was faced with a situation where a man was armed, he disobeyed commands, and what he could see at that time. And in that case, it was not clearly established that this would be a violation at that time. And so, Your Honor, I think that that would be the other grounds in which to uphold the decision. And I have this question in my brief, I know my time is up. Page 41, defendants are not aware of any case where this court has ruled that an officer, while interacting with the subject who has a gun in his hand, which the officer reasonably believes the subject is preparing to fire after the officer has announced his presence and the subject has been commanded to disarm, is not allowed to defend himself from deadly force, with deadly force. So, Your Honor, I will stop now unless you have further questions.
And under what circumstance would we have to decide the clearly established point?
If you all decide that there is a potential constitutional violation here, Your Honor, and you disagree with Judge Conrad, and so you would continue the analysis where he stopped.
Although under Saucier, we don't have to do it that direction.
That is correct, Your Honor.
We could instead affirm on the alternative ground that whatever the constitutional violation, it's not clearly established.
That is correct, Your Honor. Thank you.
Thank you. Appreciate it very much. Well, Mr. McCallum. I'm sorry, McCallum,
Your Honor.
you can take your mask off.
Your Honors, Roger McCalman on behalf of the city of Charlotte. May it please the court. In this matter, the plaintiff brings a standalone claim of negligent training against the city of Charlotte. And in doing so, as you're aware, Judge Conrad said the plaintiff provided no facts or no theory to support such a legal theory going to the jury. In this matter, what we have is two experts on the plaintiff's behalf, neither of which cite to any policy deficiency, neither of which cite to any issues with the training of our officers. What we do have is plaintiff's expert Hammering, which can be found at JA 692. He actually praises the city of Charlotte. He says we have Spanish-speaking policies related to Spanish-speaking officers and interpretation. We have training on how to deal with mentally distressed people. He actually says those trainings are sufficient, but the officers violated that training. Therefore, the plaintiff proves no evidence before this court that our training was somehow defective or it caused the incident to occur. North Carolina Court of Appeals court case Pryor versus Pruitt, that's going to be 143 NC App.612. The North Carolina Court of Appeals reviewed such an issue, and in that case, they said it could move forward. However, in that case, the plaintiff's expert found that the policies were grossly deficient. That grossly deficient policy led directly to the harm, and it was foreseeable. Here, we don't have any of that mentioned. And so we ask that you uphold the finding of summary judgment in this matter. And if you have no questions for me, I will take my seat.
Thank you.
Thank you very much, sir. Mr. Largess?
Can you start with his argument, the negligent training argument? Because
Sure.
there's not like a ton, y'all don't make a ton of an argument about it, and
Our argument below.
I frankly hadn't focused on it.
They hadn't cited a single case in support of a summary judgment for negligent training, so I didn't think that we had to respond. That was our argument in the court below. And then Judge Conrad did his own research, found cases that they hadn't even mentioned and so we're now appealing that question. The issue here, and our expert, Mr. Tucker, put in the national, I can't remember what's PERP or one of the other police organizations, their standard for dealing with a mentally ill person, said he failed to follow that. And Guerra testified that he's had crisis intervention training and used it in this 8-second encounter. He used it. And the city condoned that he properly handled a mental health crisis.
But why is that a training, right? I understand why you might want to say, you know, they're not doing a good job of supervising and you think he made mistakes, but I don't understand why that's the training piece.
Because they said that he acted consistent with his training. So if that's consistent with the training, we get a question to the jury whether the training's effective. And then you also have a policy that is praised about having a Spanish speaking.
Where in the record, where in the record do we see them saying that his actions were wholly consistent with the training?
He went through a shooting review board assessment.
No, but that's to say that we find that the shooting was not improper. That's not to say that he complied with every aspect of our training.
That's what they said. There were no training violations. That's the finding in the internal affairs and the shooting review board. It's in their brief. They both found no violations of any city policies.
No violations of policies, which is different from saying that there was inadequate training. I just want to understand why we've got a training problem here. And I see lots of allegations about misconduct, but what I don't see is anything that substantiates there being a training problem.
And all I can say, I want to get back to the qualified immunity. All I can say is that
You brought the negligence claim.
we brought the claim.
You answer your question.
No, I'm just trying to say that our theory on the claim is that they condoned what he did as being consistent with policy and training that he received. And clearly they were not consistent with the training. So this is a question of whether the training was adequate if they say he complied with his training. That's the logic of it.
But that's your whole argument, is that because after the fact, they approved what happened, or they didn't discipline him for what happened, that ergo there must have been negligent training.
That's the argument. On the qualified immunity.
Res ipsa loquitur, they used to call it, didn't they?
I don't know if I would use that, but I understand what you're saying.
That sort of sound like what you said, didn't it?
Perhaps.
I think it's fair.
Perhaps.
Anyway.
We didn't use that, but here is on the qualified immunity. It is true that this court didn't decide Hensley until 17, but Hensley was based on Cooper, which has been the law since 2013. And that was based on Pena saying that there has to be a threat. The mere possession of the gun is not enough. And in Waterman, which is cited in Stanton this year, the threat can evaporate in a second. And that's the fact question in this case. As he stands in a position of surrender with the gun hanging like that, is there any actual immediate threat at the moment he's killed? If they'd shot him when he supposedly took the gun out of his pocket, we'd have a different case. But
Is there a factual argument? What is the record cite that he did not take the gun out of his pocket? I mean, there's a lot of discussion about this.
I was trying to find it. I believe it's in Tran Thompson's interview and deposition that he just said he came out with the gun in his hand. But again, I don't think that that's sort of the Waterman question. Whether he pulled it out or showed it
doesn't really matter.
Doesn't really matter, because once he takes the position that's safe for the people involved, and they're all behind cover, all these other mistake cases and the use of force, they involve where the officer gives a command and they're approaching them and the person either drops their hands or does something threatening. This is the opposite. By the time they shoot him, he's doing what they've asked him to do, at least as he understands it. And he's
you can't say that because you don't know how he understood.
6 times you said not to bring the gun.
But he's brought the gun out.
But he was told not to. You said he was doing what he was told to do.
I'm talking about.
He was told not to come out with the gun.
Right, Judge. I'm talking
6 times, according to you.
I understand, but I'm talking about once he comes out and it's dangerous, the commands are to drop it and to raise his hands. The only command given to him in his language is manos. And when he's killed, he has both manos in the air. That's the question under Waterman, whether the time has passed where the immediate danger has passed. That's what this case is about. And Judge Conrad got past that by finding that he dropped his hand and created a threat before he was shot. And the video does not show that. That's what this case is about. And when officers are behind cover and give someone 3 seconds to comply with commands, They're not threatened in any way. They're all behind.
Not the 6 commands that he didn't listen to the first time.
Exactly. But what I'm saying is the 3 seconds in English to drop the gun. To give him 3 seconds while they're behind cover and he's not pointing the gun at anyone and to kill him. I think the jury could find that that was not an immediate threat. And under Cooper and under Waterman, it was clearly established that unless there is an immediate threat, you can't use deadly force. I think that's what this case comes to. And we should have a jury trial about that. And the video of Guerra giving such a wildly different false explanation of why he fired the gun is something that we should be able to show a jury, because he would only give that false explanation if what really happened isn't sufficient. That would be the argument we should be able to make in this case. And I think that's consistent with Waterman and Cooper. Thank you. And one other thing. Oh, I'm over.
No, you go ahead.
They haven't mentioned the NIED claim.
The what?
Negligent infliction of emotional distress claim. Which
Well, you can't even make any rebuttal to it if they haven't talked about it.
No,
you briefed it, I guess.
we did.
But you go ahead. I'm gonna let I'm not cutting you off.
All right.
You go ahead and say, tell
Thank
us
you.
what you want to say.
I just wanted to add that if the shooting was unlawful, then the elements of NIED, which is the acronym for it, are met here. It's foreseeable when they come to someone's home that someone behind the door is going to be a loved one. It's foreseeable that when they shoot someone outside the home, that the people in the home can have a sensory perception of the shooting, which is what happened. And we have this record of this woman suffering severe emotional distress as seen and coming out and seeing him slaughtered. And so I think that we have the NID claim if you find the shooting was unlawful. And there, the question just isn't the Graham question. The question is whether in all these factors of shooting someone from behind cover, which our expert, Mr. Tucker, said was one of the worst shootings he's seen in his career in terms of the lack of threat to the officers when they decided to kill. We should be able to get those issues before a jury. Thank you.
Thank you very much, sir. Thank you. Counsel, and if we weren't involved in this pandemic, still, we would come down and greet you and shake hands with you. We appreciate it. Madam Clerk, we'll reconstitute the council tables and call the next meeting.
Court will call the last case, number 212267, Benjamin Reitz v. On Hewitt Investment Consulting, Inc.
Mr. Wessler,
Yes, Your Honor.
good to have you with us, sir.
Thank you, Your Honor. May it please the court, Matthew Wessler for the appellants. Larissa's duty of loyalty is absolute. As this court has repeatedly recognized, when a fiduciary is charged with helping to make investment decisions for plan participants, there can be no balancing of interests. Just the opposite. ERISA's duty of loyalty commands undivided loyalty to the plan participants. And that requires uncompromising rigidity. Any decisions that a fiduciary makes must be made with, as this court and others have explained, an eye single to the interests of participants, not to any self-serving interests the fiduciary may also have. And faithfully discharge, if this court has also said that if faithfully discharging this duty appears arduous, that is because it is. The district court in this case failed to apply this uncompromising standard. It made specific findings that the record here, to quote the district court, clearly established that one of Aon's fiduciaries was focused not on the plan participants' interests, but instead on his own. Specifically, the possibility that Aon could sell additional services and obtain increased fees, which could, and again, I'm quoting the district court here, burnish his candidacy to become a partner at Aon. Time and again, as the district court found, this fiduciary put his own interests ahead of the plans by pushing the sales of delegated fiduciary services while simultaneously acting as a fiduciary and advising the plan on its investment decisions. Yet the court below, even though
you keep saying it, and so I want to sort of just all of the language in these cases about fiduciaries refer to investment decisions, right? You started off by saying investment decisions. These investment decisions. I have a hard time understanding why cross-selling or any kind of selling, right? If I want to get them to re-up my contract for, traditional investment advice each year, I'm selling something to them. I'm selling my own services. And I just haven't found any cases that suggest persuasively to me that decision, right, to sell you something is an investment decision. Can you help me? I understand the district court didn't cite cases or anything, but just sort of said, yes, but cross-selling here has some investment decision aspect. I'm not sure exactly how that worked, but can you help me understand why cross-selling or selling one's own services for the next year's round of advice, why that is a fiduciary investment decision?
Yep. And if I could piggyback on Judge Richardson's question, it seems to me that the statute 29 USC 1002 21A talks about this investment advice. You're a functional fiduciary if you render investment advice with respect to any money or other property. And then the CFR 29 section 2510.3-21 says investment advice involves rendering advice as to the value of securities or other property, or making a recommendation as to the advisability of investing in, purchasing in, or selling securities or other property. And how was that done at this point with the cross-selling? It just seems to me you're not meeting the definition of a fiduciary contained in the statute and in the CFR, because there wasn't a advice regarding investing in, purchasing, or selling securities or other property.
Sure. So let me maybe take Judge Richardson's question first, and then I'll.
They're the same question. If you didn't pick that up, they're actually the same question.
I would say they're slightly different, because I think embedded, Judge Richardson, in your question was whether, as a categorical rule, cross-selling constitutes fiduciary advice or can satisfy the standard under ERISA. And I would say the answer to that is no, not necessarily.
What do you say cross-selling is?
Cross-selling is it's when one individual or an entity tries to push a product in a different context. But in this case, and the question of whether it was a fiduciary act at a general level is very fact specific. So the statute lays out the standard, but whether the facts in a specific case qualify somebody as a fiduciary, it depends on this kind of question of the totality of the circumstances. And what Judge Bell found in this case, as a matter of fact, not so much the legal question, but as a factual matter, that the scope of Aon's fiduciary role was broader than just advising on individual plan investments. Its contract, and this is paragraph 19 of the district court's opinion. Its contract here was broad in scope. It allowed Aon to advise on a whole range of different investment strategies. And that's the key difference, is that what Aon was doing here was not just assisting Lowe's in picking individual fund options. It was advising the company on its strategic decision-making when it came to the kind of plan set of menus that it wanted to offer, and how it wanted to offer those menus. And the specific fact that I think justified what the district court found here, that Aon and in particular Panus, who is one of the fiduciaries that was advising Lowe's, rendered this cross-selling service a fiduciary act, was that in the exact same communication that the fiduciary is telling Lowe's, we think you should move your plan from one menu to another menu or change the structure of the plan. The fiduciary also said our delegated services product would dovetail nicely with this change in your plan menu. And so it's the scope, collectively, the scope of that advice, which is coming at the same time in the same communication, that rendered the advice on cross-selling a fiduciary act. Now, that is not always the case. It may be, Judge Richardson, as you've suggested, that in a different context, a fiduciary may not act as a fiduciary when cross-selling a different product. And I think this points up.
Right, but I'm just having a hard time understanding. It's in the same communication. So if I'm having a meeting with my client and I say, buy these stocks, and I need you to sign the contract for my services next year, right? And, this stock is going to dovetail nicely with, the work I'm going to do for you next year, that I have a fiduciary duty with respect to getting him to sign the contract for me to provide services next year?
I need to, again, I want to draw this distinction, I think as clearly as I can. We're not talking about the same services that the fiduciary is already providing to the client.
Okay, so stop. So the fact that they're in the same meeting, I'm good. That's fine. All right. So the idea that they were in the same communication goes away. I think you're right about that. But so why is it that if I'm selling my own services, right, which are not yet purchased for 2023, that's not a fiduciary duty, but if I'm selling an additional service for 2023, that is a fiduciary duty? That doesn't make any sense to me.
It depends on the nature and scope of the fiduciary relationship. And here, the fiduciary relationship is not limited to just me advising you pick this fund or pick that fund. The fiduciary relationship in this case, as the district court found, was broader in scope and included general strategic advice over the nature of the plan.
Is your argument, and is the distinction you're trying to make, because I want to come back to Judge Keenan's point, is your argument that the fiduciary duty here was broader than the statute and the CFR?
No.
Right? The statute and CFR define the scope of the fiduciary duty, not the contract. You keep saying the contract is very broad, but we look at, as Judge Keenan pointed out, the statute and to the extent it helps the CFR in defining what it is. And that requires the recommendations of securities, not the recommendation that you re-up my services for next year or that you buy pencil erasers from me too.
Sure, but it does cover the strategic advice over the nature of the plan more generally than just pick this fund or pick that fund. And what the district court found here was that Aon was providing that kind of strategic advice. Move your plan from one structure into another structure. And in the course of that advice, what Aon was also doing was saying, and by the way, in order to help you manage this new structure, purchase our separate product that we've developed, this delegated fiduciary services. And that what the district court found, as a matter of fact, again, this is a mixed question. And I think to reach an alternative conclusion, you would have to reject the fact findings that Judge Bell made here, was that fell within the scope of this strategic advising that Aon was doing throughout this entire relationship.
But my point is, and I'll stop and let you go to something else, is it can be within the scope of their strategic advice by contract, right? But if it doesn't fall within the statute, right? If cross-selling doesn't fall within the statute, doesn't matter whether it's part of the contract or not. I don't understand why it's part of the contract, but even assuming it is, if it's not if it doesn't fall under the statute, right? Cross-selling a separate service, if it doesn't fall under the statute, doesn't matter what the contract says.
Sure, but what I'm focused on is not cross-selling just divorced from anything else. It's whether cross-selling in this particular context fell within the strategic advice, which does fall under the statute as fiduciary conduct, whether this kind of cross-selling qualified as strategic advice under the statute and rendered Aon a fiduciary for its statements that, for instance, purchasing this delegated fiduciary service would dovetail nicely with Lowe's move into a different.
If Aon had a contract and part 2 of the contract said, in addition to investment advice, we will advise you on the purchase of copy machines. Right. And so we'll give you strategic advice about copying machines. Right. And so a part of your strategic plan is to buy lots of copy machines. Like that doesn't have anything to do with a fiduciary duty. Right. So if it's something that's not the making a recommendation about the nature and type of securities or the value of those securities, it's not investment advice. There's not a fiduciary duty.
Understood. And I don't dispute that at all. The line again that I'm trying to draw here is that in this particular context, cross-selling was not, we'll advise you on paper clips or telephone, plans or anything else.
Right, but track the language of the statute and the CFR and tell us why it was not.
Well, I think it's providing the advice on investment strategy. That's what, and I don't think there's any dispute, Judge Keenan, that Aon was acting as a fiduciary in providing strategic advice. That happens all the time.
Well, they were saying simplify your offerings, right?
They were saying simplify your.
Right. How does that meet?
Sorry?
The statute and the CFR.
I'm sorry, Judge Keenan, can you repeat the
How does the advice to simplify your investment offerings to plan participants meet the definition in the statute and the CFR of rendering investment advice regarding the purchase of securities or other property?
Yes, but I think the rendering advice is the key. What they're rendering advice on are the securities options, the offerings that the plan will provide to its participants and beneficiaries. If I could shift, because I do think that this points up what is the fundamental problem with the way that the district court understood the duty of loyalty. Because what you've got going on here, and I think this, Judge Richardson, in some ways gets maybe to what you were asking in a different way, is that under normal circumstances, in a case where you've got a fiduciary who is trying to wear 2 hats, maybe they are providing advice on plan management or the assets of a particular.
Are they a fiduciary on both hats?
Yes, a fiduciary
on both sides.
Yes, but if a fiduciary wears 2 hats, and this is really the key, ERISA doesn't impose a categorical prohibition on a fiduciary wearing 2 hats. But what it does do is it says if you are wearing 2 hats, you must figure out a way to clearly protect against the conflict of interest that will inevitably arise. And so, for instance, this court's decision in
fiduciary can only wear 1 hat then.
Sorry?
Fiduciary really can only wear 1 hat.
Yes, when it's acting as a fiduciary, the fiduciary can only wear 1 hat. And to make that clear, the fiduciary has to do something. Some courts have talked about it as stepping away temporarily as a fiduciary if you are also participating in a relationship as a business executive. Another court has talked about erecting some firewall between the fiduciaries that are acting as fiduciaries and the company's salespeople. But in this case.
Yes, counsel, I don't mean to interrupt you, but I just saw the clock at 2 minutes and 34 seconds. And you haven't talked at all about the duty of prudence, about the selection of the growth fund, about the failure to monitor the growth fund over a 2.5-year period. It seems to me these are pretty substantial parts of your appeal you may want to take up now.
Sure, I'm happy to focus on that. So in addition to the breach of a duty of loyalty, Aon also breached its duty of prudence. And the key piece, I think, here is to recognize that while Aon was acting as a fiduciary, it never performed the kind of meaningful investigation or analysis that's required for any prudent fiduciary who is choosing to select a new fund, and in this case, place over $1 billion of the plan participants' money into that fund. The district court recognized that fact, acknowledged that when Aon was acting as a fiduciary, it never performed the necessary investigation.
Can I ask that question? Was it so? Judge Keenan mentioned the time gap, but you seem to really want to focus on the fact that it wasn't done while they were fiduciary. Had they done like a complete and total review in, 2 weeks before they became the fiduciary? Do you think they had to redo it the moment they became a fiduciary?
Your Honor, I think that what matters is that you've done it as a fiduciary, because when you become a fiduciary is when the prudent standard actually kicks in.
So it's not the gap that causes you concern. The concern that you have is that when they did the review before, they didn't have a fiduciary obligation, or at least the same
Correct.
type of fiduciary
And that
obligation.
really matters, because if you're not a fiduciary, you could be making a decision based on any reason whatsoever.
And the district court found they were a fiduciary on what date?
At least 2 years after they had
That's
selected.
kind of vague. When?
Sorry?
What date? When are they fiduciary?
I think it was October 2013, although I can get the specific.
October of 2013.
Yeah, and though this fund was created more than 2 years before then, and it was created for business purposes. It wasn't created in a way designed to.
And that was a finding made by Judge Bell in his opinion.
Yes, correct.
After the bench trial.
Correct. Yes.
And is that reviewed here for what?
Well,
plain error?
Yeah, I think it would be plain error. I don't.
Or clear error?
Yeah.
Clearly erroneous?
Yeah, and I don't think.
Well, if it's contested on appeal.
Correct, and I don't think it is, Your Honor. So I don't think that's a dispute.
Well, there's no cross appeal about it. We know that.
No. And so in the absence of any meaningful, and I see I'm out of time, if I could just briefly finish up.
You go ahead.
The absence of any meaningful investigation or analysis or an assessment of the prudence of this option while Aon was acting as a fiduciary, there's no way that it could have met its obligations under the duty of prudence. And I'm happy to answer any other questions on rebuttal. Thank you.
Thank you very much, sir. Mr. Boyle?
Thank you, Your Honor. May it please the court. In a 120-page opinion, because it's kind of a beast, Judge Bell made dozens of contextual credibility determinations, sifted through a mountain of evidence, and concluded that Aon had met its duties of loyalty and prudence to this 401k plan. And there's nothing in that order I submit, no error in that order that merits reversal. Let me start with a loyalty claim. I think that Your Honors appreciate this. There were two theories of disloyalty below, and it got a little bit muddled in the discussion there. And I want to be really clear about this. One theory of disloyalty, one capacity in which the plaintiff said Aon was behaving disloyally was in providing investment structure advice to the plan about potentially modifying the menu of investment options. And then there was a second respect in which they alleged that Aon behaved as a fiduciary and behaved disloyally, and that was in trying to sell the additional service offering for delegated services. Only one of those was Aon actually wearing a fiduciary hat, and that namely was in providing the investment structure advice. And I think plaintiff's principal contention on that issue, the alleged mistake that Judge Bell made, according to them, is that he, in concluding that Aon had provided advice for loyal reasons, purely loyal reasons, thinking solely about the interests of the plan and participants, that the judge managed to ignore improperly a finding that he made that one of the consultants on the account, it was Mr. Panus, who's been mentioned, saw the advice as an opportunity to further Aon's delegated sale offer. And there is plenty of material in the order about Mr. Panus's interest in supporting the sale bid, supporting the sale opportunity. Plenty, but there is no finding. You'll search in vain, Judge Bell's opinion, for a finding that Mr. Panus actually changed Aon's advice on menu restructuring or colored the advice on menu restructuring because he was interested in planting the seeds for the sale. There's no such finding at all. And indeed, if you look at paragraph 288 of the judge's order, I think it's clear that Judge Bell felt like he didn't need to answer that question. You know, what would Mr. Panus have done if he were the only consultant on deck if there weren't a fuller record that began before Mr. Panus was even on the account. And he said, there's no need to, because I know one thing here, and that is that the advice that plaintiffs challenged, the menu restructuring advice, was formulated and delivered before Mr. Panus was on the account.
Can you help me understand from just a factual matter from the record? The plaintiff seems to want to connect these two, and there's some record evidence to suggest that the change in the investment structure somehow impacted the sale. So in other words, the fiduciary or the delegated fiduciary became easier or better or something because of the investment structure change, that there's an impact between those two. Can you, what did the record tell us about that?
I think the theory is that plaintiffs have or have below was that, particularly as to the selection of the emerging investment structure, which Lowe's ultimately picked, that was more likely to lead a plan to want to opt for delegated services because it was more.
So why, maybe, do you agree with that? And is there a record to support that? I mean, that's the trouble I'm having is like, because I don't know, I might think it goes the other way, right? It's a simpler story. And so maybe it requires less.
The Judge Bell didn't dwell on that because he noted that consistently throughout this process, Aon's restructuring advice was in support of the alternative menu structure, which everybody conceded was far less likely to want to incline a plan toward delegated services. It was more simple. And this gets back to my point about Mr. Panus. He was not even on the account when another consultant, Mr. Absher, for purely loyal reasons, according to Judge Bell, formulated the advice to the Lowe's plan, advocating for this menu simplification using the alternative menu. And after Mr. Panus came on the account, the advice didn't change at all. Didn't change a bit.
Well, it didn't change, but they do say, and I think the phrase they use, or at least your internal document suggests that menu shift was a starting point for, or some such phrase, a starting point for the delegated services discussion. What? Help me understand what that means.
There are some internal documents that I think came later, after June.
Yeah, but I'm just trying to understand what that means.
The internal documents, I believe, in the record suggested that one way that a client might be inclined to be favorably impressed by additional services is if they restructure their menu. And so,
But why?
Why?
Why would that be? I'm literally just trying to understand it. I know you're dancing around it too, but and maybe it's just not in the record, and that's fine. But why is the change make it more likely that a plan would adopt delegated fiduciary services?
And I'm putting myself in plaintiff's shoes. I suppose the theory is that, with any kind of change at all, a change in menu structure commands an interest potentially in more consulting services, if nothing else.
Okay.
That it's just the dynamic situation. But here the judge didn't need to go there. I think that's my reading of paragraph 288, because the advice was formulated and delivered loyally by Mr. Absher in June 2013, and it never changed after that when Mr. Panus came on the account. Indeed, the only minor respects really, that the menu restructuring advice evolved thereafter were in respects that were plainly contrary to Aon's business interest. Example being not only the alternative structure that was clearly the express recommendation of the advice consistently throughout, which was less likely, everybody agreed, less likely to lead a plan to want to delegate because there's less work involved in maintaining an alternative structure. But also the minor respects in which it evolved were after Lowe's picked the emerging structure later. Aon made additional suggestions that were contrary to its business interests here about the structure. For instance, they recommended that the plan look at a brokerage window, which would have taken assets out of the delegation entirely. So it was contrary to Aon's business interests. Let me talk about the second issue, which Judge Richardson, you were focusing on. Was Aon wearing a fiduciary hat when it presented the delegated sales proposal, or as Judge Bell put it, when it sought permission to make a delegated sales proposal. The trial court ultimately, and it used the word easily rejected that theory of breach. But I think there was a simpler basis for ruling that I think Your Honor was focused on, that Aon simply wasn't wearing a fiduciary hat when seeking to sell additional services to this plan. The trial court accepted plaintiff's contrary view.
But the trial court ruled they were fiduciary.
The trial court
You were a fiduciary.
that there's some fiduciary element to cross-selling. That is correct, Your Honor. But I think, as I'll develop in a moment, the trial court was applying an incorrect legal standard.
Why didn't you cross appeal?
Because the court can affirm the judgment, the absence of a fiduciary breach here on that alternative ground. And that's why we didn't cross appeal. But the theory was that in seeking to present a delegated sales proposal, there was something of an implicit recommendation there that the services would be good for the plan. I think that was the theory. But as Judge Keenan pointed out, the regulation says that investment advice, making investment advice makes one a fiduciary under ERISA only if that advice is as to the value of securities or other property, or as to the advisability of investing in securities or other property. And then, this is important, then only if there's a mutual agreement that that advice is going to be the primary basis or a primary basis for the plan's decision. And here, the services were not the services that were offered, and thus the implicit recommendation, if you accept that phrasing, were not about securities or other property. They were about surrendering fiduciary responsibility for the plan to a delegate. And so even if Aon had come in guns blazing and said, look, you need to delegate, you absolutely need to delegate, we'll put our reputation behind it, and you absolutely need to delegate to Aon, we're the only people who can do this, even if the record were as such, that would not have made Aon a fiduciary under the investment advice regulation. Now, let me talk about mutual agreement, because I think the plaintiff's theory fails under that test in the regulation as well. The Judge Bell seemed to accept that the investment consulting agreement itself was a sufficient basis for concluding that parties did have a mutual agreement that Aon's implicit recommendations would be a primary basis for the plan's decision-making. But I would respectfully submit that the judge's findings of fact here are fundamentally incompatible with that kind of agreement as to the delegated sales proposal. In paragraphs 130 and 131 of the order, Judge Bell specifically found that Aon never made a recommendation concerning whether to delegate, much less to whom to delegate, that the Lowe's Committee never once asked Aon for advice about whether to delegate or to whom to delegate. And indeed, that because the Lowe's Committee recognized that Aon had a conflict on those issues, a financial conflict, it would have a financial interest in selling those new delegated services, the committee understood that it needed to make that decision itself. I think the quote from paragraph 131 of the order is, Lowe's Committee did not look to Aon for those things. And so there is no, the theory that plaintiff offered at trial was unsustainable based on the trial court's factual findings here. There was no mutual agreement that with respect to delegating and delegating to Aon, Aon's views on that subject would have been a primary basis for the plan's decision. Indeed, it's hard to imagine, I suppose, at some level, how a recommendation that even plaintiff agrees was implicit, implicit in asking to make a sales proposal. There was an implicit recommendation that these services would be good for the plan. How can an implicit recommendation be the subject of a mutual agreement that it would be the primary basis for the plan's decision? It's really hard to imagine.
I do want to hear about you on the prudence.
Here's where Judge Bell's findings are especially detailed.
What?
And I think plaintiff struggles to find a real legal issue in the prudence context. Prudence.
What about the duty to monitor?
Yes, there's the duty to monitor the investments. My principal point here, and I'll just cut to the chase, is that the prudence inquiry is context sensitive. This court recognized in Tatum that there's no uniform checklist for prudence, that a variety of actions can suffice depending on the particular circumstances. And here, Judge Bell concluded that in context, the prudence duty was easily satisfied.
But we have said that the fiduciary must monitor at regular intervals.
Yes, Your Honor.
And where is the evidence that the fiduciary did that in the context of this growth fund?
Yes, it was continuous, Your Honor. And the context here is that the Aon Collective Trust and its growth fund strategy was simply a cost-effective institutional vehicle for then hiring third-party asset managers to run the plan's assets.
But it wasn't doing well over that period. Isn't that uncontested?
Well, I think that is contested. I think Judge Bell found that from a risk-adjusted standpoint, the fund was toward the top of the pack over the time it was in the plan.
Well, definitely it's a balancing act, but what is the evidence in the record that Aon systematically considered the wisdom of the continuing with the growth fund at systematic intervals or regular intervals? Sorry.
So the context is that the collective trust is just a vehicle, cost-effective vehicle for hiring third-party managers. And the analysis that Aon conducted occurred in the course of hiring those third-party managers to manage the assets in the collective trust and in firing them, replacing them. And Judge Bell goes into great detail on what Aon did during the period the growth fund was in the plan, replacing managers, reallocating assets among them, hiring new managers, taking away asset classes, putting in new asset classes. That process was continuous. And so contextually, and context is important.
Right. But where's the evidence that that Aon reviewed whether the growth fund was a good investment for the Lowe's plan in light of Lowe's interests and aims, goals? I don't see that in the record.
Well, there's abundant evidence at that point.
Okay, well, tell us a little bit about it then.
What the judge found, quite reasonably, is that this plan, given the poor asset allocation that participants on their own had achieved before the delegation, that this plan would benefit from a multi-asset growth strategy, not just stocks and bonds, also real estate, commodities, other assets, and that structurally this plan would benefit from having multiple unaffiliated asset managers running those assets, each of those managers being expert in their respective disciplines. And those findings are essentially unchallenged. And the IPS observations in paragraph 171 of the order. So here, and this was before the delegation, this was in 2013, in preparing to assume delegations, Aon had surveyed the marketplace and concluded that there were no off-the-shelf commercially available options that combined the broad range of asset classes that Aon reasonably thought would be ideal for a plan like this, plans like the Lowe's plan, and certainly none that combined the services of multiple unaffiliated managers. That's an unchallenged finding from 2013. And so when they took the delegation in 2015 and they confronted an IPS that said, an investment policy statement that instructed Aon to look for a growth fund with a broad range of asset classes, this strategy fit hand in glove. The manager diligence part of things, plaintiffs say, well, you got to consider third-party managers. You have to consider off-the-shelf vehicles. That occurred inside the collective trust, essentially through a process that was unchallenged. Plaintiffs had no criticism at all for Aon's decision-making protocols, analytical methods for evaluating third-party managers who were hired to manage the growth fund's assets, different slices of the growth fund. Nothing at all. No criticism at all of the protocols Aon followed for allocating assets among those managers. That was unchallenged.
Now, when you
And that
say
was where
no
the diligence-
criticism at all,
I'm sorry,
no criticism from whom?
from the plaintiff or his experts. Nothing. And that was where the diligence was great. That's why context is so important. Here, everybody agreed we need to hire third-party managers, right? Aon wasn't going to pick securities. The contract with the plan called for using third-party managers. The collective trust was simply a vehicle for hiring them, and a low-cost vehicle at that. I think in paragraph 201, the court's order, the court noted that this approach for hiring third-party managers saved the plan about $1 million a year. And that,
Okay, but are you talking about the initial selection or are you talking about the retention?
yes,
Because those are two different aspects of the duty of prudence.
yes, I'm talking about both. The initial selection of the collective trust was rooted in the reasonable judgment that this plan would benefit from a growth fund with a broad range
Right,
of asset
right.
classes with multiple managers.
Right, and I'm more interested in the evidence regarding retention.
Right, and then after that, I think it's after that, the diligence, the principal diligence took place at the level of the individual managers and the asset allocations in the growth fund. So, you know, from 2015 forward, there were multiple changes made in managers when some were not performing as Aon hoped. There were multiple changes in asset allocations. New asset classes were represented in the growth fund in place of others. There were changes all the way throughout. That process, that manager due diligence process, which was based on protocols that Aon had developed over decades of doing manager due diligence.
Okay, but was there any assessment whether to retain the growth fund as the investment vehicle?
They didn't need to fire the growth fund since it was simply a pass-through vehicle. What they could do if there was a manager who was underperforming is simply replace that manager and bring in another one or add in a different.
So you're saying there was no duty to consider reconfiguring this.
In this context, in this context-sensitive inquiry, I believe that is right, Your Honor.
But why is that? Because that's not totally fair, right? Because you say that the growth fund is a pass-through entity, but it's a pass-through entity that's run by a group of managers, right? Managers who are picking third parties, right? They're not managers in the sense of picking stocks, but they're managers who are picking managers, right? And so the question, I get your point. You're doing diligence at the bottom level managers, right? Making sure the people actually picking stocks are doing a good job. I think what Judge Keenan's question goes to is, are you doing something to look at what you want to call a pass-through entity? But it's not really a pass-through entity because it has people that work there, and your duty of prudence required that you evaluate whether those people were doing a good job. There's a management team for the growth fund, right? The collective trust has a management team.
Yeah, absolutely.
Right. And that management team are picking other stock pickers, right? They're picking managers. It's a fund of funds.
That's right.
Right. And when you run the people running a fund of funds, the question is, are you doing any diligence that they're doing a good job? So not that the people picking stocks are doing a good job. That's the internal prudence. The question is your fund of fund managers, are they doing a good job? And that's a separate duty of prudence, right?
I think in principle, yes. And I think at any point along the way, if Aon had concluded that it no longer makes sense to have multiple best-in-class managers managing a fund with a broad range of asset classes.
No, not the category, right? I want to talk about the particular people you chose. Because listen, in a fund of fund, right, there are people who pick better funds than others, right? They're better evaluators of talent, right? And so the question is, do you not have a duty of prudence to ensure that your pickers, right, your team that's running the fund of funds, that they're doing a good job as opposed to they're just mediocre, and maybe they think they're picking, best in class managers, but in fact, they're like doing a terrible job of
it. The Aon looked at its track record in analyzing and picking good managers.
Right. And what I'm trying to get at is tell me what in the record I can look at that Aon monitored, evaluated, considered, thought about whether the fund-of-fund managers were competent or incompetent. I mean, I'm not trying to be too blunt about it, but I mean, the question is the fund-of-fund people, they could be terrible or they could be great.
So the Delegated Portfolio Oversight Committee continually compared the growth fund to its peer group.
And so where, tell me where that is.
It's throughout the record, the Delegated Portfolio Oversight Committee.
It was in the evidence of the trial
Oh, yes.
and was found by the judge.
Yes. I mean, he says in paragraph 342, Aon kept continually abreast of the market, how other offerings in the market were doing, and there are findings that the Delegated Portfolio Oversight Committee continually looked at the growth fund relative to its peers. And, so that's my first answer. My second answer is that, if Aon concluded that, gosh, maybe it isn't a very good delegate, and there are others out there that could perform the delegated role, like Russell Investments or Northern Trust, that puts Aon in a very awkward position because Lowe's has hired Aon to be the delegate. And if Aon had turned around and said, well, we're going to hire Russell to represent the plan's interests here and after, that would have added another layer of fees. It would also have invaded Lowe's province in determining that Aon should be the delegate.
Right, but that's all on the merits, right? What I'm trying to just ensure that on the duty to monitor, right? What I want to be able to say is, yes, they were monitoring the fund-to-fund in addition to monitoring the funds themselves.
The record is very clear. There was continuous monitoring of the fund-of-funds relative to the multi-asset growth peer group. And that's in the Delegated Portfolio Oversight Committee record. Continuous. And, it was not like the house was on fire, because remember Judge Bell's other finding, he found the growth fund to be, in a separate finding, a reasonable product for the plan, in part because from a risk adjusted standpoint, its performance was at the top of the pack. It had a Morningstar 5-star rating almost throughout its entire rated history. And it was delivering superior returns for the risk that participants are undertaking by investing. And so those two things, I think, match up very nicely. I'm over time, Your Honor, but I'm happy to answer more questions.
Thank you.
Thank you very much, sir. Mr. Wessler?
Yes, Your Honor, just a few brief points in rebuttal. I think I want to pick up on both Judge Richardson and Judge Keenan's your questions to opposing counsel about what obligations a plan fiduciary has to both select an initial investment and to monitor it. And what you heard, I think, is that at the fund level, the plan was not doing any sort of prudent analysis to compare not, what are the managers doing down at the ground level, but whether the growth fund in particular was a prudent investment for purposes of this plan. And that's what didn't happen here at any point while Aon was acting as a fiduciary. The only place that the district court identified in the record in which Aon undertook this kind of comparative analysis, a qualitative analysis about the prudence or appropriateness of the growth fund, the particular fund that it put into this plan. The only point this entire case in which that happened was when Aon was not acting as a fiduciary.
What your friend on the other side says the Delegated Portfolio Oversight Committee was the group that was really charged with looking at the fund-to-fund levels as opposed to the individual fund levels. Do you respond to that?
Yeah, I don't think that's right, number one, but more importantly, here's what I think the problem is. There's a disconnect because what we're talking about from a prudence standpoint is not the substance, the merits of how well this particular fund is doing. It's a process-based question. Is Aon as fiduciary not just looking at other potential managers, but are they asking comparatively, is this fund the right fund for this particular plan? And that never happened in this case while Aon was acting as a fiduciary.
And so that was a breach of the what?
Duty of prudence, Your Honor. Duty of prudence. And the district court said that the entire...
And the district court's
conclusion that there was no breach of the duty of prudence here turned on its belief that what happened before Aon became a fiduciary could cure any problem that happened later. That's the core holding.
No, so I think what he says instead is like, we consider this in context. We consider it in total. We don't close our eyes to everything that happened before the moment they become fiduciary, but instead we evaluate the totality of the information and what they're doing. That's a different question. I mean, you're saying that we ought to close our eyes to everything that came before whatever the December 13 date.
As a matter of I think the way the duty of prudence works, it only kicks in once you become a fiduciary. So what happens before, when you're creating a fund for business purposes, does not have a bearing on whether that fund is appropriate or prudent to be used in a plan in which you are acting as a fiduciary. And there is no dispute that Aon didn't do any of that kind of comparative analysis in this case when it became a fiduciary. And
can I ask one follow-up
So
question?
they violated their duty as a fiduciary, you say, and that poisons the well. Is that right?
So yes, they violated.
I mean, we got this Bedrick. You familiar with Bedrick?
Yep, I'm familiar with Bedrick.
And you familiar with Judge Hall?
Yep.
Do you know his connection to this court?
I do not, Your Honor.
He was my direct predecessor.
Thank you.
But he said there's no balancing of the interests at the duty of loyalty.
Well, that I think is spot on.
Well,
so before Judge King, I was focused on the duty of prudence. With the duty of loyalty, which Aon breached by virtue of its effort to leverage its fiduciary relationship to sell Lowe's this product on delegated services, there is no balancing. And that's where the district court in this case went awry on the duty of loyalty, because what it said was, look, you've got several people acting as fiduciaries. You've got one guy who is.
Can I ask just a factual question? I asked your colleague, but I want to give you the chance to answer it too. But so you suggest in various times and ways that the change in investment structure somehow impacted the cross-selling of the delegated fiduciary. Can you briefly, given where we are on the time and the point in the afternoon, explain to me why the former impacts the latter?
The former is the fiduciary. Sorry.
No, sorry. So why the investment structure decision impacts the cross-selling of the delegated fiduciary?
Oh, well, in this case, one thing that Aon is saying is we're going to put, our own fund into this new structure. And it just would make sense if we're going to be using one of our funds to also have us act as fiduciary. So we're picking new funds. One of them will include ours. So it just would make sense, and there's record evidence for this. I quoted this to you earlier. There's a communication from one of the fiduciaries that says, if you're moving to this new plan structure, our delegated fiduciary services would dovetail nicely with that structure. And the reason is because Aon is using its own proprietary fund in that structure. And that, Judge King, just to get back to your question, that blurring of the lines between fiduciary hat and executive hat is exactly why there can be no balancing under Bedrick. 1 ounce of a conflict of interest between a fiduciary and the company violates the breach of the duty of loyalty. And on that duty, that's where the district court went wrong. On the duty of prudence, it went wrong because it accepted that a fiduciary can perform an analysis before it becomes a fiduciary and then check out after the fact once it becomes a fiduciary. And the duty of prudence does not permit that kind of pre-fiduciary analysis to play a role. Unless the court has any further questions.
Thank you very much, sir. We appreciate it. And if we could do so in this court, we can come down and greet counsel in the well of the court. It's been a tradition for many, many years, but we're not doing so now because of the pandemic. So when you come back next time, we'll do that with you. And that being said, we'll take your case under advisement. Madam Clerk, we will adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.